Yes, I request for that custody may be taken at each and every time, because as such today also custody is not available.
Yes, yes, we'll try and inform.
Not for we have to follow the order of Honorable Supreme Court. So sometimes last time also only for that purpose that matter was adjourned.
We'll let us not go into that, those peoples. We'll ensure that in any case, otherwise we'll ask them. We are in process of getting their presence secured, not just in this matter, but in other matters as well, through video conferences. Because sometimes what happens is that because of the JAPTA not available, they are not producing it here. So that is the only reason why we'll do that. Anyway, thank you. 26. Yes.
Yes, others and mokli do. Saksi some PC others. PW. બોલાવતા નથી પછી
બોલાવી લેશું ભલે આપણે
26 ની છે પણ તમે ના આવતા 24
આવે એટલે કહી દઈશું. યસ
સિરિયલ નંબર 12.
બે વિટનેસ છે આપણે 2 મિનિટ આ પૂરું થાય જસ્ટ લઈ લેવું. યસ 13 એમાં બી 3 વિટનેસ છે 108 2022.
હા સર એમાં બે વિટનેસ આયેલા છે સર તો બે વિટનેસ ગોકુલભાઈ અને સતીશભાઈ
કઈ વાત 2 મિનિટ રોકાવો હવે એડજસ્ટ કરીને લઈ લો. જી
તે મિઝેલરી એપ્લિકેશન
જી આવ્યું છે એમાં પેલી એફિડેવિટ પેલું એમના રિમાર્ક્સ
નોટ સર 24-30 પાસપોર્ટ ની અરજી છે હજુ પેપર નથી આવ્યા
આવે એટલે ઓપિનિયન આવે એટલે લઈ લે.
only one issue sir he has to travel tomorrow evening.
Sir, you acha possibly because I was on leave, therefore
No,
this has been
as soon
delayed.
as I got the ticket, immediately I filed this application.
Anyway, let us see.
Please.
બપોર ના જોઈએ.
હા એટલે ગઈકાલે
એમને જરા કેવડાવી દો ને એવું લાગે. જી જી
સેમ ફરિયાદી કે સેમ ટ્રાન્સફર ની છે પેલા નીચે બી મળી આવતા નથી તો આ રિસ્ટ્રીક્ટ કરવા માટે છે આપ મને કહો તો હું વિડ્રો કરી દઉં છું. એક તો એકે સાલ સાહેબ ની કોર્ટમાં છે સેમ ફરિયાદી સેમ આરોપી હવે નીચે બી આરોપી હાજર નથી અહીંયા પણ આઈ થિંક તો એવું સાંભળવા કે ફોરેન જતા રહ્યા ઓર્ડરિંગ
એમાં શું થયું શેરો શું આવે છે ભજવણી
હા અહીંયા શું આવી
વર્ષો જતા રહ્યા
હા ચલો
બરોબર ઠીક લો. કેમ આમનું સમન્સ નથી કર્યું આની પર શેરો માર્યો? અચ્છા અચ્છા ઓકે. આમાં પ્રોપરાઇટર નું નામ શું છે ઈષ્ટદેવના?
હા એ મુકેશભાઈ કે
મુકેશભાઈ પટેલ. આરોપ બી જતા રહ્યા છે ને એવું છે ને?
જી આરોપ.
ને અત્યારે એમાં ઓર્ડર એવો જ કર્યો છે કે આઈ વિલ પાસ બીકોઝ આઈ વિલ પાસ મેઇન ઓર્ડર એડમિનિસ્ટ્રેટિવ સાઇડમાં હુકમ કરતો હોય એ રીતના હું કંઈક કરી દઈશ બીકોઝ આઈ ડોન્ટ વોન્ટ યુ ટુ વિથડ્રો ઇટ. It is always better that it is decided on merits. એટલે મારી રીતના હુકમ કરીશ એમાં. જી. આ કયું સિરિયલ નંબર? આ આવતીકાલે હુકમ ઉપર હા.
જી સર ઓનલાઈન.
જી. તારા માટે છે એ બપોર પછી હુકમ થશે.
જી જી.
થઈ ગયું. Oh, this is to implement the insurance company. You have only implemented the bank. Indian banks ne તમે implement કરી છે. You have not implemented the insurance company per se. So my request is કે એને implement કરી અને પછી let the notice be served. Thereafter I will take it up for final hearing. હા એટલે તમે implement કરવા માટે એને અરજી આપી દો આજે. ઇન્સ્યોરન્સ કંપનીનું નામ જોઈ લેજો આની અંદરથી. જી.
સિરિયલ નંબર 222. મુસા વ્યક્તિની રકમ બેંકના અધિકારી અરજદારને આપે અમે અરજદારના પિતાનું નામ રમેશભાઈ છે એમ કરીને અમે અરજી આપી છે. પેલામાં પંથુલાલ છે, પંથુલાલ રમેશભાઈ મીણા એ રીતે અમે એપ્લિકેશન આપી છે.
ડોક્યુમેન્ટ્સ
ક્યાં છે મેં આધાર કાર્ડ પાન કાર્ડ બધું રજૂ કર્યું છે. એફડી અમારી જોડે છે.
સાર આવતીકાલે
અપ્લાય.
સિરિયલ બોલાયેલો witness ને. રાણી સાહેબ છે.
રવિભાઈ ને બોલાવો. આરોપી ત્રણ જણા હાજર છે. ડોક્ટર સાહેબ
હા 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 હા
ઉભા કરો ને.
ઉભા રહી જાઓ બધા. અને કઈ તારી વાઈફ? બહાર બાળક સાથે
હા વાંધો નહીં.
સર
છે સર છે.
ગોકુલભાઈ સતીશભાઈ શારદા કોઈ એકદમ બોલાય. ગોકુલભાઈ આવી જાઓ. સતીશભાઈ થોડી વાર બહાર બેસો.
બે જ witness છે કે ત્રણ છે?
ત્રણ છે સાહેબ, એક નથી આયા સર. એક કઈ out of state.
ખાલી જોઈ લો ને પોકાર કરજો અહીં બેઠો ના હોય અંદર.
કેમના ભાઈ? દશરથભાઈ.
દશરથ.
દશરથભાઈ નથી આજે? ઓકે
દશરથભાઈ
કઈ વાંધો
આવી ગયા. ડોક્ટર આવી ગયા.
તો ડોક્ટર હોય તો પેલા લઈ લે એમ.
એટલે ડોક્ટર આવી ગયા.
2 મિનિટ બેસો તમે થોડી વાર. 2 મિનિટ બેસો.
બે ડોક્ટર છે. એક જ આવ્યું. હા.
બે મિનિટ
હા, સર.
જાઓ.
Yes.
23-22 ડોક્ટર છે.
How is that you went before the court?
The resolution was challenged by some inter-rivalry political persons of the municipality board. Some councillors, some corporators have taken an objection before the collector. So ultimately, under the pressure of that part, there was likelihood to cancel the resolution and to withdraw the permission.
So that challenge.
I tried a shoot. Ex parte injunction was granted. By parte it was confirmed. It was challenged by way of an appeal before the district court. District court dismissed the appeal on merits. Thereby the injunction was confirmed till the final disposal.
Ji.
Thereupon a trial took place. Matter was.
See, I want to understand this first. I want to understand the scheme of that act because you know if a resolution is passed by a municipal body, then under what law is to be challenged before the collector?
Under section 258 of the Municipality Act.
258.
258.
Okay. Upon an act.
I have annexing my
Written submissions?
in written submission. That provisions I have annexed.
1 minute.
आपने कोई
Can you-
नुकसान है तो I would take about 1 hour.
I have answered. You don't take your own time, sir. Section 50 you have quoted, sir.
258 also is there.
250 unfortunately I did not find.
Address.
છે તમે annexure તરીકે મૂક્યું છે.
Please.
Okay. So that is power of collector to suspend execution of orders etc. of municipalities.
Just an administrative power that I have annexed the judgments of our High Court.
1 minute. In the opinion of the collector, the execution of the order resolution of municipality or doing anything
Subject
about
to
to be done
judicial.
by the way of the is causing likely to cause injury or annoyance to the public or to lead to breach of peace, so is unlawful. He may be ordered in writing as on the signal to suspend the execution of prohibit the doing. So આમાં whether it is unlawful એમ કરીને એને બતાડવું પડે. Whether collect writing and under signature suspend the execution so and so and whether
Collector entertained that appeal also, which was filed by one of the councillors. Who has participated in the meeting where unanimous resolution was passed. Where in meeting he has not taken any objection.
No.
Subsequently, he challenged.
I'm just trying to understand the provision.
Please.
Provision એવું કહે છે કે unlawful હોય So suspend करे execution or prohibit the doing thereof, and where the execution of any work in person or order resolution is already commenced or completed, the direct the municipality to restore the position which it was before the commencement. And any niche may prefer an appeal to the state government. Municipality can go to the appeal. Okay. So you said that because of this, you were now a proceedings ni andar.
My submission is to that effect,
Hmm.
that even whatever may be the order passed under section 258
Ji,
by a collector, it's an administrative power being exercised by that
collector.
officer.
Okay.
So it is always subject to a judicial review. And therefore, a civil court required to have its independent finding to that of the any order passed by the collector.
No, but that order was never there. You had preempted, you had come before that order.
Before the order was passed.
Correct. So therefore, that question of reviewing under this proceeding does not arise.
Collector has suspended that resolution.
Ah,
It was conveyed late to the municipal board.
okay.
Before that, municipal board has passed a resolution
For what?
regarding that extending the promotion to a present appellate committee.
So there was already a order.
So now the civil court took that.
ના સર તો રિઝોલ્યુશન એક જ મિનિટ રિઝોલ્યુશન જે હતું એ તો પહેલેથી જ હોય પછી જ પેલો એને ચેલેન્જ કરવા માટે કલેક્ટરમાં જાય કરેક્ટ એટલે એ તો રિઝોલ્યુશન હતું જ
Agenda was published.
ઓકે
Some facts are required to be.
જી
Agenda was issued to every council,
કરેક્ટ
wherein one item was
હા
to give the promotion to
ઓકે
So that item was challenged
Hmm.
by one of the councillors
Hmm.
before the collector that these items should not be transacted in the meeting.
And what are the grounds in that? Are those copies of those proceedings before this court?
They say that the body has, the general body has no power under the law
Ah.
to give the promotion.
You show me that power.
It should be, that's the only narrow question to be examined with.
Okay, so your power, we have reached to the controversy now.
It's a controversy running into very narrow compass.
Ah, so come on.
Still, I require to demonstrate some fact.
जी
If your order would permit me to, I will proceed step by step.
आपने परमिट કરી દીધા છે ક્યારથી આપ બતાડવાના છે
Then let me start.
જી
So kindly appreciate. This present appellate plaintiffs have been in service since from 1993.
જી જી
An advertisement was published in 1993.
હા
On 13 September 1993.
Hmm.
Inviting the applications from public at large.
Hmm.
For the post of PU. A fresh recruitment regarding it.
જી
So that advertisement is on record at exhibit 129.
જી
Both the plaintiffs have applied for being an eligible for the post
There are
of
two plaintiffs.
PU.
બે plaintiffs છે
Both two plaintiffs. So interview call was issued to be interviewed by a selection committee constituted by a municipal. That is exhibit 130 and 131. A interview call.
જી
Selection committee selected them. And then by virtue of that, they have been appointed as a PU on 27th October 1993, exhibit 132, 133. Both had the appointment letters.
કઈ exhibit 130
132, 133 appointment letters appointing them as a PU. But they have been confirmed in service by order dated 3rd January 1996. That confirmation order is at exhibit 134, 135.
જી
Now in the year 1999, there were some vacant posts of the clerk since long in the municipality.
Ji.
And the municipality was facing the trouble, some administrative difficulty for want of filling up the seat post.
Ji.
So thereupon, a municipality decided that on a vacant sanction post shall be filled by way of a promotion to the most senior few who are eligible to be a clerk.
Because it's supposed to be filled by,
In 1999,
filled by promotion.
by awarding promotions to the most senior few.
Sir, before you move ahead,
Please,
question is, what are the rules applicable for promotion, sir?
please, that is rule is that exhibit 142.
એ તમે રિટર્ન સબમિશન માં મૂકે છે રૂલ્સ?
અંદર એ એને એમાં જોડ્યા છે. Reproduce પર particular rule કર્યો છે.
કયું છે રૂલ નંબર?
142 exhibit
Exhibit 142
થી રેકોર્ડ છે. આ રૂલ્સ આખા
142 આપો તો exhibit.
આવું નીચ પ્રશ્ન. તમે CL નંબર 16
એક મિનિટ.
exhibit
exhibit क्या
124 નું લિસ્ટ.
142 exhibit જુઓ છો.
14 नंबर
એને પેલું mark
Serial number 14 14.
ને mark લગાવી દો. પેલું. હા. 142 કીધા ને તમે સાહેબ?
List exhibit 142.
142.
Forwarding letter of sanction.
આ ઓર્ડર છે in exercise of power of government under so and so.
Next thing, immediately next page is the rule.
એક જ મિનિટ. આ નિયમો 10. નિયમ 10 એવું લખ્યું છે ઉપર એ ટૂંકી સંજ્ઞા નિયમો so and so 1991 ના નિયમ એ ઓર્ડર છે એ જ મળ્યો.
એની જોડેનું next page
એના પછીનું.
real નિયમો શરૂ થાય.
હા
કર્મચારીઓની ભરતી અને સેવાની શરતો નમૂના રૂપ.
Please.
Oh.
Now, relevant rule your honor will find
હા
at page 5.
સીધી
Rule
ભરતી.
Page 5, rule 9.
આ 7 છે ભરતીથી નિમણૂક.
Please.
Oh.
So this is the question of promotion.
જી
The matter of promotion.
જી એમાં નગરપાલિકે કોઈ કર્મચારી સિનિયોરિટીના
નગરપાલિકાનો કોઈ કર્મચારી કે સિનિયોરિટીના કારણે ઉપલી જગ્યા ઉપર બઢતી મેળવવાને અવતાર થશે નહીં. નગરપાલિકાના કોઈ પણ કર્મચારીને સિનિયોરિટીની ઉપરાંત એવો કર્મચારી એવી બઢતી માટે ગુણવત્તાના આધારે યોગ્ય જણાય તે સિવાય ઉપરી જગ્યાએ બઢતી આપી તો seniority come merits. Not only seniority is sufficient,
હા
but merits are also to be considered.
નગરપાલિકાના કોઈ પણ કર્મચારીને સિનિયોરિટી ઉપરાંત એવો કર્મચારી એવી બઢતી માટે ગુણવત્તાના આધારે યોગ્ય જણાય એટલે seniority.
Seniority come merits.
એક જ મિનિટ.
A ground for extending the
પણ
promotion.
એ કઈ જગ્યાએ મતલબ આ this is from,
Any post from lower post to higher post.
so then you will have to show me the posts કે પ્યુન
It
પછી
is
તરત
a
જ આ
general rule
હા
sanctioned by the director of municipality. And this is the only rule applicable to municipality. Second, કોઈ પણ જગ્યા પરની નિમણૂકની ભરતીથી કરવાનો હોય ત્યારે પસંદગી સમિતિ સંબંધિત કર્મચારીની શૈક્ષણિક અને બીજી લાયકાતો અને ખાનગી અહેવાલો વિચારણામાં લેશે અને સમિતિ ભરતી માટે યોગ્ય જણાય તે કર્મચારીના નામની જણાય નિમણૂક કરનાર અધિકારીને પણ જે કોઈ કર્મચારી ગુણવત્તા આધારે ઉપરી જગ્યાએ ફરજો અને જવાબદારીમાં અદા કરવા માટે દેખીતી રીતે યોગ્ય ન હોય અને જેની નિમણૂક તે જગ્યાના કાનૂની કાર્યક્ષમતાને પ્રતિકૂળ રીતે અગર પ્રતિકૂળ થવાનો સંભવ હોય તે કર્મચારીની પસંદગી સમિતિ સુપરવિઝન કરવાની
ભલામણ
ભલામણ
કરીશું.
કરીશું.
એક જ મિનિટ હો. એક
ઇંગ્લિશ વર્ઝન પણ છે સાહેબ જોડે જોડે. આ ગુજરાતી હતું અને જોડે જોડે ઇંગ્લિશ વર્ઝન પણ છે.
સમજાયું છે?
હા એ લીધું. રનિંગ પેજ 9 જેવું ગુજરાતી.
એક જ મિનિટ.
ગુજરાતી પતે પછી.
જી. આમાં સિરીઝ તમે
Nice.
appointment by promotion, no employee of the municipality shall be entitled.
Seniority come merit, that is the basic ground,
Okay,
basic criteria.
એક જ મને પેલું આપણે
Not only seniority is sufficient, but meritorious part is also to be considered.
થેન્ક યુ. આ તમે અંગ્રેજીમાં ફરીથી વાંચી જાઓ ને એકવાર.
Please.
Appointment by promotion.
Promotion.
જી.
No employee of the municipality shall be entitled to a promotion to a higher post. On the,
Only on seniority.
only on the ground,
Ground of seniority.
only of a seniority.
Ah.
No employee of the municipality shall be promoted to the higher post unless in addition to the seniority, such employees found to be suitable on merit for such promotion.
Okay.
So there is seniority come merits. Here seniority is not sufficient.
પછી નંબર ક્લોઝ 2 વાંચો જરા.
Two, where an appointment to any post is to be made by a promotion, the selection committee shall consider consider the educational and other qualifications and confidential record of the concerned employee and recommend the name of employee who is considered to be fit for promotion by the committee to the appointing authority. The selection committee may recommend supervision of an employee who is apparently not found to be suitable on merits to discharge the duties and responsibilities of a higher post and whose appointment is likely to affect adversely the efficiency of the work assigned to that post.
Sir, sorry to be very technical. What I mean is that, there has to be a list of posts where it would be indicated કે pune પછી આ જે છે ને તમે clerk જે કહો છો ને, that would be the next one, and that, there are different posts. દરેક જગ્યાએ. These are very general rules.
This is general, this is general.
They are very general.
For every employee.
એટલે pune માંથી દરેક whether it will apply to all posts or select posts મને ખબર નથી. એટલે તમારે આવા કોઈ નિયમો ખરા કે એ લોકોનું રિટર્ન સ્ટેટમેન્ટ જોઈ લે પહેલા? Let us see the written statement first.
Officer
હા
came into the box
હા.
and he has admitted so many things with regards to this rule also.
ના રૂલ તો ઠીક છે. What I mean is કે એ લોકોનો ગ્રાઉન્ડ શું હતું? એમ કે છે કે આ રૂલ અપ્લાય જ
They
નતા થતા.
simply said the municipality board has no power
ઓકે.
to give a promotion. That is their basic defense.
તો આ જે આમાં કે છે આ જે by promotion, so who will exercise this power under 9?
Board has exercised. That's what they are challenging.
પર board will exercise this. તો એ કઈ જગ્યાએ? Where is it provided, sir?
That is under section 50, which is section 49.
Of this act, Municipalities Act.
Which is
Yes, power and duties of the chief
section
officer.
50. Section 50.
50, 50.
I agree. મારા compilation.
હા, એક જ મિનિટ. Yes, appointment of other
Appointment
officers and
of
servants.
Other officers and servants.
So other is what?
Officer meaning that a chief officer, a designated post,
Ah,
other than the designated post.
okay,
Appointment of other officers and servants of the municipality. A municipality may, with the previous sanction of a director. Thus, this a word is very important. Municipality may,
ah,
with the previous sanction of the director,
Hmm.
create such post.
Hmm.
So for creation of a post, previous sanction of the director is bound to be there.
ah,
Create such post of a officer and servants other than those specified in subsection 1, 2 of section 47, that is chief officer and chief accountant.
Ji.
It shall be deemed for the purpose of, it shall be necessary, it shall deemed necessary for the purpose of carrying out the duties under the act.
Hmm.
A creation. Now second, the recruitment of such officer and servant and their condition of a service shall be such
Ji.
as may be determined
Hmm.
in accordance with the rules made under section 271.
Hmm.
The rule which we have referred under exhibit 142.
Hmm.
It is made by exercising the power under
Under
section
270.
271.
Okay,
Subsection 3. The power to make an appointment in any post referred to in subsection 1 shall vest in the municipality. Now this is important.
Ji.
The power to make appointment in the post referred to in subsection 1
Hmm.
shall mandate,
Hmm.
shall vest in the municipality or in the authority empowered by the municipality
Hmm.
by rules made in this behalf under section 271. So, two authority has been conferred with a statutory power
Hmm.
by virtue of section 50 subsection 3.
Ji.
One, municipality itself vested with a blanket power.
Ji.
Or the authority empowered by a municipality by a rules made
As framed under
in this
271.
behalf under section
271. Okay.
Now, exhibit 142 is the rules framed under section 271.
Okay.
Now, kindly appreciate in entire rules, nobody has, no authority has been empowered
Hmm.
by a municipality
Hmm. To exercise this
to
power.
exercise the power to extend the promotion
Hmm.
or an appointment.
So therefore municipality alone will do it.
Only.
Correct.
Only.
Okay.
And now the basic defense is only to the tune
Hmm.
that the resolution in question
Hmm.
by which a promotions have been extended by municipality to my clients,
Hmm.
present plaintiffs.
Hmm.
As per the contention of defendant, a municipality has no legal right to give a promotion or to give any recruitment.
Hmm.
They say only chief officer has got a power.
Hmm.
Kindly.
Okay.
So this is an order of promotion signed by a president
Hmm.
on the basis of the resolution passed in general board.
Hmm.
They say this is written by or author of the appointment or promotion order
we
is
look
the
in-
president.
Can we look into that provision where we say that any authority is empowered? Any in the cover per se, when a municipality is to exercise power, how does it exercise? Or whoever is the next, supposing there are two, as the provision says, 271 says, or 270 and the rules je kare aur, rules provide that either the municipality per se will do it or any authority which has been empowered under these rules.
This is my submission.
Correct.
In entire rules,
There is no empowerment.
empower rules are not there at all conferring the power upon
So,
any authority.
Correct, so
Other
municipality,
than the municipality.
correct, so municipality when it exercises powers, is it by way of the chief officer? Or as you point out by the president, any jogvayu hase ne, because how it acts municipality, that also needs to be understood.
I just I'm remember, a municipality would pass a resolution. It's a collective decision of entire board.
Correct, એ મને provision
Either by
દેખાડો.
majority
See,
or an elimination.
I am familiar with a company law. એમાં board of directors memorandum પ્રમાણે કરવાના હોય છે. આની બી એવી જોગવાઈઓ હશે કે either the chief officer, because chief officer as nomenclature indicates appears to be some executive limb જે પેલો જે board president કરે એના આધારે કામ કરે. પણ મને એ જોગવાઈઓ જોઈ છે, એ મને ખાલી દેખાડજો.
આપને બતાવો છે.
જી. એ જોઈને પછી આપણે આગળ વધીએ so that I understand કે whether it's the executive limb or is it the municipality which exercise કરે છે, શું કરે.
Kindly see my
જી.
written submissions para.
એની જોગવાઈઓ પેરાગ્રાફ પછી જોઈએ આપણે.
Remember that provisions.
ઓકે,
I remember that.
હા જોઈ.
Section 49 subsection B.
જી.
Section 49 subsection B. Next in my compilation.
Power and duties of the chief officer તમે લખો છો બરાબર.
That what is the administrative head?
હા એમ નહીં, પણ મને મ્યુનિસિપાલિટી નું સ્ટ્રક્ચર સમજવું છે. કંપની નું સ્ટ્રક્ચર હોય ને તો આ જોઈ લઈએ આપણે. ચાલો
આપની એક section વાંચી
49 જી.
1/1 in compilation.
હા મળી ગયું મને. Section 49.
Please. What's the power and duties of the chief?
Correct.
But straightway I am inviting your honor kind attention to B. Even A may be seen, subject to control, direction and supervision of the president. Supervise the financial and executive administration of the.
ના માળખું કેવું છે ને એ મારે સમજવું છે. પ્રેસિડેન્ટ ઉપર આવે એ બધી જોગવાઈઓ હશે ને ક્યાંક કે એને બોર્ડ મ્યુનિસિપાલિટી will comprise of such and such board or president comprising of these many, એના પાવર આવો, ચીફ ઓફિસર આવો, એ ક્યાંક જોગવાઈ શરૂઆતમાં જ હશે. મને ખબર નથી. ગુજરાત મ્યુનિસિપાલિટી એક્ટ કાઢી લો ને જરા.
પછી આપણે
કાઢી લો ને જરા.
scheme of the act જોવો પડશે.
હા એ જરા.
જેમાં constitution of the board.
That is what I am trying to understand.
There a body is a supreme body.
પેલી આ જે પ્રેસિડેન્ટ વાળી છે તે.
Elected body is a supreme body. Therefore, I am inviting your honor kind attention to B. Take step to give effect to all decision or a resolution of the municipality.
કરેક્ટ.
So if the municipality is a boss.
કરેક્ટ. એટલે ઓવરલેપ થાય ને. સપોઝિંગ ઇફ મ્યુનિસિપાલિટી ને સત્તા હોય કે તમારે આટલા આટલા તમારે કરવાના, અને સપોઝિંગ સત્તા ચીફ ઓફિસર ને એમ હોય કે પ્રમોશન નું તમારે જોવાનું. એ એમ જસ્ટ ટ્રાઇંગ ટુ અન્ડરસ્ટેન્ડ બીકોઝ ઓલ રેઝોલ્યુશન એ છે ને, resolution and this what do you call it, decisions, these are all policy matters. Please understand. એક મિનિટ મારી ક્વેરી સમજી લેશો તો આપને જવાબ દેતા ફાવશે. હા.
We require to consider a statutory provisions and rules framed under the state statutory.
ઓકે.
Both are on that.
કરેક્ટ.
Now question would be, in this case, there is no clashing with the statutory rules with the statutory provisions. Otherwise, principal act would begin.
કરેક્ટ.
Well settled. But I don't say or don't submit that there is some clashing between them.
જી.
I am simply pointing out that as per section 50, subsection 3,
જી.
other than municipality authority, nobody has been empowered to have a recruitment or a promotion. Under the rule framed under section 271, I can understand that in exhibit 142, somebody have been nomenclature that you are conferred with the power to have an appointment promotion, then municipality would be reluctant to exercise that power, and the authority empowered under section 50 subsection 3 would exercise that power.
Correct, correct.
But in absence of empowering provisions under the rule, conferring the power upon any authority, ultimately who would confer the power? Municipality would confer the power, being a supreme body. So here, a municipality has chosen not to confer any power. Its own power, statutory power conferred under section 50 to any authority by framing the rule under section 270.
Oh, I understood.
And 271 exercise of framing the rule, it is always subject to sanction of director of municipality. If you honor which is exhibit 142, any preamble એ રીતે start થાય છે કે આ director of municipality એ sanction કર્યા છે તે power, તે rules છે.
જી.
So my respectful submission is
You say only municipality can.
only defense from the defendant side is that resolution which is passed, it is without authority of law in as much as municipality has no power to have a recruitment or to extend the promotion to another.
Okay.
That is the only defense all throughout. That is the only defense. They say this power could have been exercised by a chief officer and by nobody else.
Because આ વાંચતા છે ને આપણે sometimes somebody might just think આજે આપણે વાંચીએ ને કે to give effect to all decisions and resolutions. So resolutions and decisions appear to be in the nature of policy decisions. Broad decision જે હોય ને એવું લાગે આપણને. પણ પેલું જે minute individual case ની અંદર promotion consider કરીને આપવું, that may not be covered under 49. એવું મને prima facie sometimes one tends to believe from the language, not otherwise.
Which any resolution includes the present resolution.
Okay.
Resolution when section in a wisdom of the statutory paper of the statute, the word used resolution. If they intend to have any specific kind of resolution, it would have been narrated accordingly.
Gee. So therefore everything
So
is
at
covered.
which stance we require to interpret the provisions of.
Okay.
We can't add something, we can't qualify something, and to interpret the provisions of it.
Okay.
So a statute, where a question of interpretation of a statute would arise or occasion would arise, then the words as it stands is to be considered.
Okay. હવે આપણે પેલું તમે જે ફરીથી જતા હતા ને,
Please.
એટલે we were there at 1999 vacant post of the clerk હતું.
Please.
Vacant sanction filled to promotion by the senior peon, promotion to the senior peon એવું હતું.
Please.
Most senior peon. એ પછી તમારે વધારે નરેશન બાકી છે સર.
May I start
જી જી
from that stage?
જી જી.
Please. So in 1999, a municipality were facing a trouble for want of a clerical power.
That you understood.
manpower.
હા.
So
એને
there
જરૂર
is
પડી. આપણે એને ડાઉટ નથી કરતા.
there were already vacant posts.
Hmm.
Created.
Huh? હા. જી.
Created and sanctioned by director of municipality.
Okay.
As per section 50 subsection 1, creation power, it is always subject to the sanction of a director of municipality.
Yes.
So it was already created, sanctioned, post were vacant so far as the post of class are concerned.
Yes.
Not only one or two, but about some more than 20 posts were made at the level. So municipality chosen to have filling up that vacant post sanctioned by a directed municipality
Hmm.
by way of approach.
Hmm.
But there are two modes of recruitment.
Direct and promotion.
Direct recruitment or by way of extending the promotion from the department itself.
Yeah.
So they chosen
Hmm.
that let us some two posts immediately be required to be filled up
Yeah.
to face the workload.
Hmm.
So they issue the agenda.
Hmm.
Item number 27 was there in the agenda.
Yeah.
The agenda is on record at exhibit 138.
Yeah.
And item number 27.
Yeah.
That let these two posts of plan maintained, sanctioned and created and sanctioned. A new creation is not there. It is already created, sanctioned, but vacant.
Hmm.
Be filled up by way of the promotion from the most senior two people who shall satisfy the criteria of seniority cum merits along with educational qualifications and experience and everything.
Yeah.
So subject to satisfying that a qualification criteria
Hmm.
or eligibility criteria for the post of class.
Hmm.
Now that resolution is on record at exhibit 139.
Yeah.
Now what had happened, sir? Well, agenda was circulated to all the municipal councillors.
Hmm.
One of the councillor, namely Devji Bhai Parmar,
Yeah.
chosen to challenge the same by preferring an application under section 258 before the collector.
Yeah.
The collector exercised the power under section 258.
Hmm.
I have annexed the section 258 also.
Yeah.
That's serial number 1.
Yeah.
And chosen to
Hmm.
direct the municipality
Hmm.
not to transact the business at item number 27 in the meeting which was held on 26th March 1999.
Take it. 26 March.
26th March 1999.
This was the proposed date of meeting.
Date of meeting. So direction was to the effect not to transact the business.
What is the date of this direction?
Date of
Direction. As in, when did collector direct this?
it is on at exhibit 165. Within a month. It must be around that. It's produced by dependent municipality. 165.
जी
It is produced by the country.
what is the date?
Yes. Intimation. If it's 150, I will only reflecting the day on which it was served.
When was it? Direction date? Direction ni date खबर नहीं.
Exact date of order of collector is not.
Anyway, for
It's
intimation.
there.
एक
It is
मिनट.
on record.
एक मिनट. Intimation letter ની date કઈ છે?
Intimation letter date is 24th March 1999.
And when was this actually
The
intimated?
letter dated 24th March 1999, served on 26th March 1999 at 11:17 minutes. But that is an endorsement. It's a production from the defendant, sir.
Yes.
65.
जी. So just
Where in the bottom part endorsement is there.
जी
કે 11:17 ને સવારે આટલું મળ્યું.
जी
એમાં મ્યુનિસિપાલિટીના પ્રમુખને એને સહી કરી.
बराबर છે.
So before that resolution was already.
બરાબર છે. 11:17 વહેલી સવારે થઈ ગયું છે.
સવારે 9.
એમાં એજન્ડામાં પેલું ટાઈમ ને સર્ક્યુલેટમાં મીટિંગ નો ટાઈમ કર્યો છે સર્ક્યુલેટ?
Wait, you know, agenda is on record.
जी
I may point out on the agenda.
એજન્ડા અને એમાં કઈક મિનિટ પેલું આપ્યું હશે.
Now, within. Exhibit 138.
એ એજન્ડા છે પછી પેલું સર્ક્યુલેશન હશે ને નોટિસમાં હશે એને જે એજન્ડા સર્ક્યુલેટ કર્યો એ નોટિસમાં that you come at this time.
Agenda માં જેમણે time લખ્યો હોય.
જી અથવા નોટિસમાં હશે બેમાંથી એકમાં તો હશે જ. Because municipal councillor ને જ્યારે તમે સર્ક્યુલેટ કરો
Please.
ત્યારે you would tell them that you come and attend at this time and day.
ભાદરા નગરપાલિકા સામાન્ય સભાની તારીખ 26/18 ને શુક્રવારના રોજ સવારે 10:30 કલાકે રાખવામાં આવે. મીટિંગ નો એજન્ડા
10:30 નો કે
10:30 મિનિટ.
98 છે કે 99 છે? આમાં બધામાં 99 લખાયું તમે. તમે આ જે મને લખાયું ને જે એન્યુઅલ ઇન્ટિમિડેશન પેલો લેટર કલેક્ટર નો જે છે ને એમાં 99 બતાડો છો તારીખ અને આમાં 98 વાંચ્યું કદાચ તમે.
ના 99.
એમ નહીં.
આમાં પણ 99.
અને પહેલામાં આ જે એજન્ડા સર્ક્યુલેટ
Exhibit 138 એજન્ડા પણ
99 જ છે.
99.
10:30 99 10:30 કલાક.
10:30 વાગે સવારે.
Okay, so it was communicated on the very day, but after this meeting was.
After passing the resolution, after everybody has signed the
Ji.
minutes procedure.
Ji.
Now, that is a non-disputed fact.
Hmm.
That is non-disputed fact.
Hmm.
question that a person who has challenged that agenda item not to be transacted as a prayer before the collector under section 258. A very person was present in the meeting.
And he has not objected there.
It's an unanimous resolution, there he consented to pass.
Okay, unanimous resolution, sir. Okay,
It's an unanimous resolution.
unanimous resolution.
But subsequently, he withdrawn that application from the collector office. He passed the affidavit before the court also. Okay, I am not objecting this resolution. It is there on record.
Okay,
Only question thereafter, so far as events are concerned.
Yeah.
After passing a resolution, in resolution itself, rule 9 has been quoted.
Yeah.
Kindly see that resolution, exhibit 139. That's very important. But the validity of the same is under a consideration.
yeah, 139. One
139. After agenda. After agenda. 138 is agenda, 139 is resolution.
एजेंडा ठीक है, 27 तो ख्याल છે.
નહીં.
હવે resolution.
139.
હા,
Mary.
yes please.
પાટલા નગરપાલિકાના પટાવાળા અનુક્રમે મુકેશભાઈ અંબાલાલ કાછિયા, શાંતિલાલ બસરામભાઈ રબારી તરફથી કારકુન તરીકેની બઢતી મળવા માટે આવેલ માગણી લગત નિયામક શ્રી નગરપાલિકા અમદાવાદને ભલામણ કરવા સંદર્ભે ચર્ચા વિચારણા કરતા ઉપરોક્ત બંને પટ્ટાવાળાઓની કામગીરી સંતોષકારક છે, તેઓ બઢતી લાયક કારકુનની શૈક્ષણિક લાયકાત ધરાવે છે. પાદરા નગરપાલિકાનું કુલ મહેકમ સેટઅપ 164 જગ્યા મંજૂર થયેલ છે. આ પૈકી હાલ પાદરા નગરપાલિકામાં 125 જગ્યાઓ ભરાયેલ છે અને 39 જગ્યાઓ ખાલી છે. So created sanction post and filled how much and vacant how much. તે પૈકી હાલના પટાવાળા તરીકે ફરજ બજાવતા બઢતી સિનિયોરિટી પ્રમાણે અનુક્રમ નંબર 1 મુકેશ કુમાર, 2 શાંતિલાલને બઢતી મળવા માગણી આવેલ છે અને આ સિવાય ચોથા વર્ગમાંથી કોઈ બઢતી ઉમેદવાર નથી. નગરપાલિકામાં નિવૃત્ત કારકુન કર્મચારીઓની જગ્યાઓ ઘણી ખાલી પડે છે. નગરપાલિકા પાદરાએ ભરતી બઢતીના નિયમો બનાવેલા છે, જેની મંજૂરી નિયામક શ્રી અમદાવાદ પાસેથી મેળવેલી છે. નગરપાલિકાની હદ ઘણા સમયથી વધી છે. બાકી પડતા વેરાની વસૂલાત, ગટરની કામગીરી અને ચૂંટણીઓની કાર્યવાહીના કામોમાં ભરાવો રહે છે, જેથી વહીવટી મુશ્કેલીઓ ઊભી થાય છે. ખાલી જગ્યાઓ પર નવી ભરતીઓ કરવાનો ઘણો જ સમય લાગે તેમ છે. તેવું સભાનું માનવું છે. આથી ખાલી જગ્યાઓ પર મજકૂર 2 કર્મચારીઓને બઢતી આપવા ભલામણ કરવાનું સર્વાનુમતે ઠરાવવામાં. This unanimous resolution. That this Devji Parmar has not objected.
Yeah, how do you show that?
Nor he disclosed that he has already applied under section 258 to the country.
Devji Parmar.
Devji Parmar.
How are you showing that he has not objected? Because it is unanimous. Okay.
He signed as a consenting party.
ये क्या है signature है?
That is within their record.
अच्छा,
I
not in.
have provided certified copy of the resolution. And they stated this is And they admitted in a cross examination also chief officer, KT done and USP passed.
जी
I am going to refer that cross examination of chief officer.
ठीक है, we'll take it for हाँ
Please.
जी
So thereupon, exhibit 140 and 141 is the appointment order. Dated 17th April 1999. Date of resolution is 26th March 1999. Kindly appreciate.
जी
And date of appointment order issued on 17th April. Intervening period was there in implementing the resolution.
99 માં જ ને આ
99.
ના એટલે એ તો 2000 થયું હશે ને પેલું માર્ચ સોરી આ બરાબર છે
માર્ચ 9 છે
જી જી
અને આ ચોથા મહિનાની 17/4/99.
જી
17 ને 20 દિવસનો વચ્ચે ગાળો છે.
જી જી
કોઈ મેચ ફિક્સિંગ જેવું હોય તો બીજે ત્રીજે તરત જ એપોઇન્ટમેન્ટ ઓર્ડર ઇસ્યુ કરી દે.
જી
Now, immediately review on issuance of that appointment order. On the next day we review. And then
એટલે 18/4/1999 માં તમે you joined the duty.
review.
Ah.
Review. Thereafter, some political movement started interest rivalry with amongst these councillors, elected councillors. Who all had participated in the meeting, unanimous resolution was passed. Now subsequently, for the base reason known to some of the group of the elected councillors, they started to agitate. So we had an anxiety that under the pressure of that rival councillors,
જી
our promotion would be withdrawn. That was an intent. The pleadings are there in the play to that effect.
જી
So we filed a suit.
જી
For an injection, restraining the defendant municipality from causing any reversion to the plaintiff from the promoting post, that is a post of clerk to the post of you.
જી
Honorable court was pleased to grant an injection.
એક્સ પાર્ટી અને બાય પાર્ટી બંને મળી ગયો
Even district court confirmed the same in appeal by dismissing the appeal of the municipality.
જી પણ આ બધા ઇન્ટરિમ હતા બરાબર ને
It.
જી
Then trial was commenced. By in the exhibit 1 prayer was to the effect, in addition to an injection, that a resolution by which a promotion has been extended to us, and a valid resolution, that declaration is also sought.
જી
Because of some valuation part, matter has been transferred from Vadodara to Vadodara. The trial was already commenced.
જી
After some evidence of defendant was over, matter was at the stage of something argument. But because of that valuation part, matter has been transferred. The senior division court might have been started there in the part.
બરાબર
So matter was transferred there to part.
જી
But there, a learned judge, after hearing the parties, chosen to dismiss the issue.
What was the grounds on
Now,
dismissal?
that's a relevant para I would point.
Ji.
Relevant para. The last thing find at page 20, para 24. There are 24, 25 and 26 are material. The real finding.
जी 24 में बनावने list of date and events આપેલા
List
છે.
of events whereby he specifies upon the day on which that Devji Farmar approach under section 258 to the collector. They on which the learned collector passed an order. And day on which it order was communicated to the municipality.
जी
Upon that even learned judge focused on and came to the conclusion. But this is a derogation of an order of the collector passed under section 258, which is the statutory powers. It appears that they have avoided to have a service of the order of the collector, and they illegally transacted the business.
जी
Even in contravention of that order of the learned collector directing not to transact the business, item number 27 of the agenda. That they transacted. In any way, learned judge ultimately comes to a conclusion that because of that derogation of that order of the learned collector, this resolution is passed by a board, though it is unanimous. It is illegal resolution. Number one. A promotion has been extended to a plaintiff on the basis of that resolution order. Consequently, promotion order is also illegal. In addition to that, further qualified findings, not the learned judge, that as the defendants contend, municipality or the president, as the case may be, have no power under the law or under the rules to grant the promotion to any employee, including the president.
Does the court specify as to who actually holds this power?
Chief office.
They say. And for what,
That
under what
was the
provision?
contention from the defendant side.
Ah.
The findings to the tune that promotion order could have been signed only by a chief officer. The president has got no power. But in a vague way, not to extend the promotion, not to be a author of the order of promotion. Two aspects, kindly appreciate. One is, a president cannot be a author of a promotion order for the purpose of communicating to the employee concerned. Basically, by saying
Okay.
that law does not confer the power.
No, I am more concerned with this president cannot be author is a different aspect altogether. I am more concerned with the provision to which the promotion is. It is nobody's case that promotion can never be granted. Somebody has to grant a promotion, correct? Okay, તો grant કરવાનું જ છે.
Please.
But who is to grant it? That is a question with you. What you say is that it municipality has the power.
Findings against me.
No, but what you contend is that the municipality has a power. What they say is no, municipality does not have a power, but chief officer will have the power.
Unfortunately, section 50 was altogether ignored.
Gee. No, what I'm saying is that if they say that somebody else has a power, then honorable court would have stated so, that under
But
this
the
provision,
authority has got a power.
under this provision, એવું આવે છે discussion.
There, one GR has been produced.
Okay.
Very. It's a GR of 2002.
આપણે વાંચીએ, let us read 24, 25, 26, thereafter we'll go to the GR.
જોડે annex કરેલું છે ને? એક memo જોડે.
Please read these 3 paragraphs, sir.
Piछલી part statement very close.
Para 24, on page 19.
Please. So, what? There are 20, 25.
Ji.
24 is the list of events.
Ji.
ઉપરોક્ત બનાવોની શ્રેણી ધ્યાને લે. વાદીઓની બઢતી કાયદેસર રીતે અને કાયદેસરની પ્રક્રિયા અનુસરીને કરવામાં આવે છે એવું કહેવું ધરાવવું કઠિન છે. કારણ કે કલેક્ટરશ્રીએ વખતો વખત પ્રમુખ શ્રી પ્રભાબેન ગિરધરભાઈ ચૌહાણ કલમ 228 હેઠળ
આ વખતો વખત કેમ કે છે? એકથી વધારે વાર ગયા છે?
only a one.
Okay.
258 હેઠળ અટકાવેલ હોવા છતાં પ્રમુખ શ્રી પીજી ચૌહાણે કલેક્ટરશ્રીના આવા મનાઈ હુકમોને બાજુ પર મૂકીને more than one મનાઈ હુકમોને બાજુ પર મૂકી તેની અવગણના કરે, જેથી વાદીઓની બઢતી પ્રક્રિયામાં વાદીઓ અને પ્રતિવાદી નંબર 1 પ્રમુખ પ્રભાબેન ગિરધરભાઈ ચૌહાણ વચ્ચે મેળાપી પણ અને વાદીઓની બઢતી પ્રક્રિયામાં રાજકારણ ખેલાયેલ હોવાનું સૂચવે છે. મેં આપનું એટલા માટે ધ્યાન દોર્યું કે રેઝોલ્યુશનની ડેટ અને અપોઇન્ટમેન્ટ ઓર્ડર વચ્ચે 20 દિવસનો ગાળો.
જી.
કોઈ એડવાન્સ ઇન્ફરન્સ બીજે જ દિવસે ઇમિડિયેટલી આપી દીધું હોય, તરત રિઝ્યુમ કરી દીધું હોય એવી સિચ્યુએશન ને રાજકારણ ખેલાયેલા હોવાનું સૂચવે છે. ગુજરાત મ્યુનિસિપાલિટી એક્ટ 1963 ની કલમ 258 જોવામાં આવે તો જિલ્લા કલેક્ટરશ્રીને નગરપાલિકાઓના ઠરાવો હુકમોને અમૂલ મોકૂફ રાખવાનો હુકમ કરવા, આ ઠરાવો હુકમો રદ કરો. આવા ઠરાવો હુકમો સામે મનાઈ હુકમ ફરમાવવા માટે તેમજ ઠરાવો હુકમોના આધારે નગરપાલિકાએ કોઈ કૃત્ય કરેલ હોય તો તે કૃત્યને પહેલાની સ્થિતિની પુનઃસ્થાપન કરવાની સત્તા કાયદા હેઠળ આપવામાં આવે છે. જેથી કલેક્ટરશ્રીને સત્તા કાયદા દ્વારા જ મળેલી છે, ત્યારે જો તે ઠરાવ ક્રમાંક 106 નો અમલ મોકૂફ રાખવા માટે કે તેને રદ કરવા સામે કોઈ મનાઈ હુકમ આ અદાલત દ્વારા ફરમાવવામાં આવે તો તેમ કરવાથી કલેક્ટરશ્રીને કાયદા દ્વારા મળેલી સત્તા ઉપર તરાપ માર્યા બરાબરનું થશે. As if the civil court would encroach upon the jurisdiction of the collector.
Sir, one more thing I just
Please.
want to understand. See, there are 2 different ways in which an order can be interpreted. One is like for the purpose of contempt, in the sense that if I do an act without having the knowledge of the order, then I would not be deemed to have committed any contempt.
Question of breach.
Breach. However, the effect of the order is not dependent on the date on which I get to know. I may have acted bona fide because I am not knowing the order. But once that order is communicated to me, then that order would take effect from the date on which the original order was passed. Correct? Once I know it. Here, what your contention is that, because by the time that order came to be communicated, it has become infructuous. Why? Because you have already passed that resolution.
So far as transaction of item number
27
27 is concerned.
એ થઈ ગયું હતું
Please,
એટલે પછી એ ઓર્ડર નો મતલબ નથી, ઇન્ફ્રાક્ચોર્સ થઈ ગયો છે.
it's a limited order.
હા કે કરવું નહીં
Directing not to transact the business.
એટલે એ તો ટ્રાન્ઝેક્ટ થઈ ગયો હતો.
Transacted.
હા એટલે therefore
Now,
now
there is no
somebody will
further injunction from the collector
હા
that now you don't implement that resolution.
કરેક્ટ, આઈ અન્ડરસ્ટેન્ડ, વેરી ગુડ. પ્લીઝ રીડ. હવે પાછા આપણે
Please.
જી પુનઃસ્થાપન કરવાની સત્તા કલેક્ટર કાયદો આપે છે. જિલ્લા કલેક્ટરને સત્તા કાયદા દ્વારા જ મળી છે ને જ્યારે ત્યારે જો તે ઠરાવ સો માફક રાખવામાં આવે રદ કરવા સામે કોઈ કાયમી હુકમ અદાલત દ્વારા
જિલ્લા કલેક્ટર આ સત્તા કાયદા દ્વારા મળી છે ત્યારે જે ઠરાવ નંબર 106 અમલ મોકૂફ રાખવા સામે
એક જ
કે તેને રદ કરવા સામે
એક
આ
હા જી
Please.
મારે there is a video conference with honorable the high court.
Subject to-
ના
Subject to order.
2:15 ના છે પણ એટલા માટે ડિસ્ટર્બ એટલા માટે પણ એનીવે પ્લીઝ કન્ટિન્યુ સર.
મારે બી હાઈકોર્ટ જોડે વિડીયો કોન્ફરન્સ થી 3:30 વાગે જોડાવા
જી જી
એક મેટર
જી
પ્લીઝ.
યસ
અદાલત ભરવામાં આવે તો તેમ કરવાથી કલેક્ટર શ્રીને કાયદા દ્વારા મળેલી સત્તા ઉપર તરફ માર્યા બરાબરનું કૃત્ય થશે. તેથી તેઓ મને હુકમ આપી શકાય. વળી ઉપરોક્ત શ્રેણીબદ્ધ બનાવો જોતા હાલના દાવાના કામે જિલ્લા કલેક્ટર શ્રી વડોદરા જરૂરી પક્ષકાર હોવા છતાં વાદીઓએ ઇરાદાપૂર્વક જિલ્લા કલેક્ટર શ્રીને પ્રતિવાદી પક્ષકાર તરીકે જોડે નથી. કારણ કે જો વાદીઓએ કલેક્ટર શ્રી ને પ્રતિવાદી પક્ષકાર તરીકે જોડેલ હોત તો કલેક્ટર શ્રીએ કરેલ વખતો વખત કરેલ મને હુકમ આવે તો અન્ડરસ્ટેન્ડ હાઉ more than one money હુકમ રેકોર્ડ પર રજૂ થાય અને સત્ય હકીકતો હાલના દાવાને શરૂઆતમાં તબક્કે રેકોર્ડ પર આવે તેમ નથી. જે દાવાના અંતે પ્રતિવાદી ચીફ ઓફિસરના પુરાવાના તબક્કે રેકોર્ડ પર આવેલ છે. આમ પ્રતિવાદીઓએ વાદીઓએ અદાલતની પ્રોસેસનો ઉપયોગ કરેલ જણાય છે. Now para 26. હવે ઠરાવ ક્રમાંક નંબર 106 26/99 જોવામાં આવે છે. આ ઠરાવ પ્રમુખ શ્રી ચૌહાણ નગરપાલિકાની સાધારણ સભામાં પસાર કરે છે. સાધારણ સભા પ્રમુખ અને ચૂંટાયેલા સભ્યોની બનેલી છે. આ સભાને સરકારી નોકરીમાં ભરતી કરવાનો વર્દી આપવાનો અધિકાર નથી.
જી
Learned judge is carrying the notion in the mind કે આ ગવર્મેન્ટ જોબ સરકારી નોકરી છે. That is the notion appears to be prevailing in the mind of learned judge. આ સભાને સરકારી નોકરીમાં ભરતી કરવાનો કે ભરતી આપવાનો કોઈ અધિકાર નથી. નગરપાલિકામાં નવા કર્મચારી ભરતી કરવાનો અને જૂના કર્મચારીને ભરતી આપવાની સત્તા ચીફ ઓફિસરને રહેલી છે. It's a clear findings now. અને ચીફ ઓફિસરે પણ તેમ કરતા પહેલા નગરપાલિકાના નિયામકશ્રીની મંજૂરી કે પૂર્વ મંજૂરી લેવાની હોય છે. હાલના કિસ્સામાં વાદીઓને ભરતી આપતી વખતે નિયામકશ્રી દ્વારા બહાલી આપવામાં આવેલ મોડેલ ડ્રાફ્ટના રૂલ્સનું પાલન કરવામાં આવે નથી. આ મોડેલ ડ્રાફ્ટ રૂલ્સ ગુજરાત મ્યુનિસિપાલિટી એક્ટની કલમ
વાદીઓએ આ 142
મોડેલ ડ્રાફ્ટ રૂલ્સ એક્ઝિબિટ 142 ની રજૂ છે. તેમાં ક્યાંય જણાવેલું નથી કે નગરપાલિકાના પ્રમુખ માત્ર સાધારણ સભાના ઠરાવના આધારે બઢતી આપી છે. આ નિયમોના અનુક્રમ નંબર 9 પર સ્પષ્ટપણે જણાવવામાં આવેલ છે કે કોઈ પણ જગ્યા ઉપર નિમણૂકની બઢતીથી કરવાની હોય તો પસંદગી સમિતિ સંબંધિત કર્મચારીની શૈક્ષણિક બીજી લાયકાતો અને ખાનગી અહેવાલો વિચારણામાં લેશે અને સમિતિ બઢતી માટે યોગ્ય જણાય તે કર્મચારીના નામની ભલામણ નિમણૂક કરનાર અધિકારીને કરશે.
હવે આ જે પસંદગી સમિતિ છે એનું કોમ્પોઝિશન શું હોય છે?
That would be constituted by municipality itself.
ના ભાઈ પસંદગી સમિતિ કરે ને આ તો
Ultimately, who would constitute?
Oh,
a parental body.
correct.
Supreme
So,
body.
constitute.
The Supreme Body has taken over that power for the purpose of promotion. So far as fresh recruitment is concerned, a selection committee may be inevitable one. But when there is
So,
an urgency,
if I am understanding your submission, there is no selection committee. Yes,
no, it's a resolution passed by general body. It's a resolution passed by general body. Contending in a resolution that there is exigency to meet with the workload and to grant the promotion.
Okay.
આજ પરના કિસ્સામાં કોઈ પસંદગી સમિતિની રચના કરવામાં આવેલી કે પસંદગી સમિતિએ વાદીઓની બઢતી થવા કોઈ ભલામણ કરેલ નથી. વળી તે રૂલ્સના પાના નંબર 3 ઉપર 6(1) માં સ્પષ્ટપણે જણાવેલ છે કોઈ જગ્યા ઉપરથી નિમણૂક નગરપાલિકાના નિયામકની મંજૂરીથી નગરપાલિકાના નિયમો દ્વારા વખતો વખત ઠરાવે એવી રીતે એટલે કે सीधी भर्ती.
So director's permission again is not taken.
Please.
Director's concurrence or permission as it is called. What is it? Manjuri.
Statute, that is my case. It's an unwarranted contention. When the statute doesn't require to have any sanction, can it be said that or for want of sanction that action is illegal?
So let us go to this rule 6(1).
Please. 142 again.
Rule 6(1).
Please.
Qualification as regards age, education, experience and manner of appointment to a post.
1. The appointment to the post shall be made in such a manner, such as a direct selection, promotion or a transfer, or by a transfer, as may be prescribed by rules by the municipality, with the approval of director of municipality from time to time. The qualification with regard to age, education, and experience should also be prescribed in the rules.
So rules
So this is required regarding the rules.
ના રૂલ્સ ની હેઠળ કરવાની અને પછી કે રૂલ્સ માં કહ્યું હોય કે ના કહ્યું હોય પણ ડાયરેક્ટર ની અપ્રુવલ જોઈએ. That is how it reads. Maybe prescribed as may be આ જે છે ને the appointment so and so may be prescribed as to be done as may be prescribed by the rules by the municipality with the approval of the director of the municipalities. એ approval તો જોઈએ જ ને. How do you discard this phrase?
Power has been blankly conferred upon the
Municipality, but with the approval of the
section.
director and municipality has to be independent. It can't be municipality જેના મારફતે એક્ટ કરે છે આ લોકો કાઉન્સિલર્સ મારફતે. Director is not one of the councillors. So yes, it's in any case when a councillor, let us assume for the time being what you say is right. A municipality acts through this body of this pramukh and councillors. Then also, if it was so, then this rule would not have, this act would not have provided. Rules check act rules.
This is rule.
The rules would not have provided that this thing would be again approval of the director per se would be needed. Director is certainly not an appointed individual. Sorry, he is not an elected individual. And a director to હશે ને કોઈ IPS શું કહે છે એડમિનિસ્ટ્રેટિવ સર્વિસ વાળો ડાયરેક્ટર તો એ હશે ને. હા એ જ કહું છું એટલે એનો અપ્રુવલ જોઈએ જ ને.
That is for the purpose of creation of the post.
એમાં ક્યાં કીધું છે અપોઇન્ટમેન્ટ ની વાત કરે છે ક્રિએશન 6(1) ની વાત કરું છું. હા.
When statute confer a blanket power to a municipality.
Blanket ક્યાં છે with approval લખ્યું છે આ ફ્રેઝ કેમ ઇગ્નોર કરો છો એમ કહું છું.
Rule under 7279.
Correct. 271 ના જ rules ની appointment ની વાત જ 271 નીચે છે ને.
Can this rule take away the powers of a municipality?
No, no, it says those powers are regulated. Powers nonetheless, but it is regulated by this director. कि भाई approval જોઈએ director નો, otherwise this becomes redundant. In any case, they are not saying that director will appoint it. They are only saying that director, once you appoint it, they have to be approved by the director.
It has been sent to the director also.
Of course, communicating is different from approval, sir. Sir, communicating is different from approval, sir. You have to approval, you have to seek. The municipality will have to write to the director, and director will then approve whatever, for whatever reasons. So, the energy relevant પેલા હોય ધારા ધોરણે મુજબ કરે ને. જી.
Regarding the rest of the part, that is criteria and other things.
Yes, now let us come back to the judgment again.
Link. So I would argue on that 6-1.
જી, જી.
Let us complete.
હા.
નિયામકશ્રીની કોઈ મંજૂરી પૂર્વ મંજૂરી મેળવવામાં આવી ઠરાવ નંબર 16 તારીખ 16 ના રોજ પસાર કરવામાં આવે ત્યારબાદ સદર ઠરાવને મંજૂરી આપવાની વિનંતી કરતો પત્ર પ્રમુખ શ્રી ચૌહાણ નિયામકશ્રી 7/4/99 ના રોજ લખે છે. So a letter was sent to the director of municipality. It's not that it is hidden to the director and even sought for a sanctioning the resolution. It amounts to a short for an approval. I would later on I would argue on that aspect. Okay, નિયામકશ્રીએ પૂર્વ મંજૂરી મેળવવા માટે સ્વયંસેવક કરવામાં આવે ત્યારબાદ સદર ઠરાવને મંજૂરી આપવા વિનંતી કરતો પત્ર પ્રમુખ સ્વયંસેવક લખે છે પરંતુ નિયામકશ્રી મંજૂરી મળ્યાની રાહ જોયા વગર પ્રમુખ શ્રી ચૌહાણ વાદીઓને ભરતી આપતો હુકમ 17/4/99 ના રોજ કરી દીધો. ત્યાર આજ દિન સુધી ઠરાવ વાદીઓને આપવામાં આવેલ ભરતી હુકમને નિયામકશ્રી મંજૂરી મળેલ હોય તેવો કોઈ પુરાવો પક્ષકારોએ રજૂ કર્યો નથી. આમ વાદીઓને ભરતી આપવા પ્રમુખ શ્રી બીજી ચૌહાણના પૂછીને આપી સુધી નિયામકશ્રીના હુકમને બહાને મળેલ હતી. ઉલટું પ્રમુખ
જશો તો વાંધો નથી અને અહીંયા બી we will not press charges against him. એવું કરો પછી હું ત્યાં વાત કરીને મેજિસ્ટ્રેટ સાહેબ જોડે એવું લાગે તો બંનેને મોકલી દઉં. ત્યાં સુધી ડ્રાફ્ટ તમારો છે ને હું કબજામાં રાખું એમ નથી આપતો. અમે કોર્ટના કબજામાં રહેશે એ કાલે તમે કાલે બંને જણા ત્યાં જઈ આવો અને એ સોર્ટ આઉટ કરી આવો. પછી જે છે ને ડ્રાફ્ટ હું અહીંયાથી આ ભાઈને હેન્ડ ઓવર કરી દઈશ એટલે તમારે પેલું ના થાય કઈ તકલીફ ના પડે બરાબર. એવું એક અહીંયા આ ડ્રાફ્ટ લઈ લો અને બપોર પછી મને એફિડેવિટ કરીને બતાડી દો. જી હું મેન્શનિંગ પછી બપોર પછી રાખો મારે મીટિંગમાં જવાનું છે. થેન્ક યુ.
3 વાગે આવો.
ત્રણ વાગે આવો. ત્યાર પછી આવશું. બરાબર. 3 વાગે આવો.
આજ બધું લઈ જાય.
આપણે તો મારે કઈ
હાલ આ ગુલાબી
માંગો તો આપે નામ માંગો તો કઈ ગયા
ના બાકી સેલના માટે તો રિપોર્ટ આપો.
સાહેબ ક્યાં છે સ્પેશિયલ? ઓકે
This honorable court has heard him on last October.
એક જ મિનિટ લેટ મી જસ્ટ રિકલેક્ટ. હા હા પેલું હા જતા. What are your initials, sir?
Sir, I'm Advocate V.V. Dushi, appearing for applicant in this case.
Advocate V.V.
Dushi, D-U-S-H-I-N-G.
D-U-S-H-I-N-G.
Yes.
Yes, sir.
Yes. Sir, admittedly, this is successive bail application.
Ji.
My first two bail applications were rejected by Honorable Special Court.
Ji.
Later on, this applicant, this accused, went to Honorable High Court. In the Honorable Gujarat High Court also, his bail application was rejected. That order was challenged before Honorable Supreme Court. And however, in SLP, Honorable Supreme Court did not interfere because of certain reasons. So I will point out those reasons. Admittedly, sir, I have to point out to this Honorable Court the maintainability of this petition, this bail application. Sir, this is my successive bail application. So for that purpose, I need to point out change in circumstance. So first change in circumstance is after rejection of my bail application in Gujarat High Court, the two other co-accused who are similarly placed in the charge sheet have been released on bail while order passed on 1st February 24 and 7th February 24.
Let us look at those orders first.
Yes. At serial number 5. Sorry, Sultan.
Sultan, yes.
Orange one.
Yes.
Yes, Sultan. That is at serial number 5.
Yes.
Paragraph number 4 is important for us.
Ji.
The learned APP for the respondent state has opposed grant of regular bail looking to the nature and gravity of the offence. It is submitted that the role of present applicant is clearly spelled out from the papers of charge sheet. Learned APP submitted that there are material and evidence available on record indicating involvement in the present offence and also suggests that the applicant is a leader of gang and his involvement of the applicant is found out. It is therefore urged that present application may not be entertained. Then, sir, paragraph number 6 may kindly be seen.
So you say that, it is after charge sheet, then the investigation is complete?
Yeah, it was decided after charge sheet.
Ah.
However, why I am claiming parity on the basis of this order?
Ji.
Because my application got rejected in the month of December 23. Later on, Honorable Gujarat High Court granted bail to the co-accused who is similarly placed on 7th February.
No, see, investigation is complete is common to both of you.
Yes.
Charge sheet is finally also common to
Right,
both of
sir.
you. You are in jail since what time?
Since 1st February 2021.
21.
Almost 4 years. Yes.
And how many offences are considered against you, sir?
There-
That is important.
Yes, sir. In FIR, there are 13 offences. In all, 13 offences are shown against me.
Hmm.
Out of them, only one offence is post promulgation of Act of 2015. Only one offence. That is 1st December 2019 is the date of promulgation. But I would like to point out the brief story of that offense also. If this honorable court kindly considers, there was one person, namely Anthony, who was arrested in some other case. And at that time, COVID was going on. So police had taken that person to government hospital for his COVID examination. There, when he was handcuffed, he pushed some police officers and flee away from the custody of police. Later on, he was found on next day, along with his family members, his mother, his wife, and his driver. They were traveling from one vehicle, Innova vehicle. He was found, that Anthony. And during the course of investigation, police found that said vehicle was standing on my name. And therefore, this present applicant was implicated as an accused after 6 long months in that case. Sir, in that case, initially charge sheet was filed against 5 persons, including Anthony's mother, his driver, and his other aides. In that charge sheet, I was not shown as wanted accused or absconding accused. Later on, there are some interesting facts, sir. In order to invoke provisions of this act, this FIR is registered on 19 January 2021. And surprisingly, police all of a sudden filed charge sheet against me on 18 January 2020. 1 day prior to registration of FIR.
For this Anthony offence.
For this Anthony offence. This is the only offence. In that offence, my lords will see, in that offence, there are no sections of 109 abatement, neither there is section of conspiracy, 120B.
Ji.
So that offence has been registered under section 332, that is assaulting public servant, and section 224. 224 is jailbreaking or breaking the custody and evading arrest.
So how is the only because the car is there?
Only his family was traveling in my car. I was implicated in that case as an accused. Sir, for your ready reference, I have brought that charge sheet.
You produce it by way of an
Yes, sir.
application.
So I'll show you. And sir, in my list of document, if this honorable court kindly sees last few pages,
Yes.
I have annexed screenshots of the that case, which would show that cognizance of that particular offence, that supplementary statement, has been taken by the learned magistrate on 10th February. That is almost a month after.
Which documents are you referring to?
Last 4 pages. Last 4 pages.
E-courts નું છે આમાં 16236 એની વાત કરો છો?
4938, sir. Filing number. At serial number 9, sir. I have given page number. Serial number 9.
જી.
Yes, sir. That is the CC number 4938. Registration date 10th February 2021.
Okay.
And offence in question is filed on FIR in this offence is filed on 19th January 2021. So technically, while according sanction under section 20 subclause A, there was not a single offence post 1st December 2019.
Therefore, this is hooked up, you say.
Yes. So just to slap provisions of Gujarat Terrorism Act,
एक मिनट. जी.
as far as
આ છે ને ભાઈ આ કંઈક નંબરમાં ભૂલ કરી છે આ દલીલો કોઈ બીજી મેટરની જ લાગે છે. This is something else. એક મિનિટ. Okay, sorry. Okay.
yes. So now, sir, in their affidavit at page number 66, they have shown one chart.
એક મિનિટ.
I would like
ક્યાં
to-
છે?
Sir, affidavit.
આ છે ને? Okay.
Page number 66.
જી.
Affidavit.
Yes.
So there are in all 5 offences shown to have been
Page
registered.
number 66.
66. Thanks.
જી.
There is a chart.
જી.
So this was at serial number 1. This is the case which I just now told this honorable court. This is in respect of Anthony. Sir, as far as second case is concerned,
જી.
all the offences mentioned in this are punishable up to maximum punishment is prescribed for 2 years. That is for section 506.
No, your next is Navapura police station.
Yes,
Is
sir,
that what you
Navapura.
reading?
Now,
There the સજાની જોગવાઈ છે 3 વર્ષ કેદ અને દંડ અને બંને એવું
that
કીધું
is
છે.
wrong, sir, because only section 506 is there. 506 part 1. There he was not yielding any weapon, not nothing of the sort. So as far as 506(1) is concerned, punishment prescribed is 2 years. And
Okay.
they have considered 506(2). And for that punishment is up to 7 years. All other offences, sir.
Ji.
All other offences, 269, 270, 269, 6 months, 270, 2 years, 294, 3 months. And 294B, part B, is 3 months. And only 506 prescribes punishment up to 2 years. And they have considered in order to show that this offence falls under the category of this act, MCOCA.
પછી જેલમાં ગયા બાદ ગુના બે કર્યા છે એમણે.
No, sir. So I am coming on that point. Sir, while considering my bail application before Honorable Gujarat High Court, at that time, prosecution was successful in showing that during the custody, he has committed these 2 offences. So for that purpose, I would like to state, sir, as far as offence number 2, PCB police station is concerned, that has been caused by Honorable Gujarat High Court.
Okay.
But that order is annexed at serial number 7, sir, orange plates.
Okay.
That order is there.
Yeah, I'll read it.
That has been quashed. That was the only offence which can be treated under this act, being 384. The other offence at serial number 1 is concerned, it is violation of some COVID rules and norms. And punishment for that is prescribed payables.
Okay.
So, sir, as far as offense number 1 is concerned, and sir, I would like to point out the brief fact of that offense. Sir, accused were produced from VC before this honorable court, before the predecessor court of this honorable.
एक मिनट जी
Gotri police station. As far as Gotri police station is concerned, accused were produced through VC. At that time, court clerk was busy in some other work. So accused was repeatedly asking him about the charge sheet, whether charge sheet in my case is submitted or not. The then clerk appointed for the in this court, he felt offended. At that time, some officers from crime branch were present in the court. So they felt offended that they thought that accused is threatening the court clerk from VC.
Okay.
And he was forcing him to hand over his charge sheet.
Okay.
And that is how the crime branch officers asked the registrar to register an offense. Registrar is not a eyewitness. He was not threatened. The concerned clerk's evidence is already recorded in lower court. That registrar's evidence is also recorded in lower court. In their entire cross-examination, not a single ingredient as alleged is fulfilled after considering their cross-examination.
Do you have copies of that?
Yes, sir, I have annexed it. Serial number 8.
Where
Serial number orange.
just read out that, please. जितेंद्र છે ઈ પેલા છે રજિસ્ટ્રાર છે
जी सर, first PW.
हाँ.
विमल भाई is registered.
તલાક ઈ વિમલભાઈ તલાટી
Registered.
sorry registrar
Registered.
and this guy is
And
Jitendra is the
Bhai
court
is
the court clerk.
Right.
Okay. So
His cross examination is important. He has stated that I never felt offended. It was suggested in
what is the first line signify આ વાળા પત્રમાં district judge સાહેબે તેઓના કર્મચારીઓ રિસીવ કરેલો હોય તેવો કોઈ શરો નહીં. What does it mean?
district judge has not endorsed the letter which was forwarded to crime branch for registration of offense. That was not endorsed by the court.
Okay.
Court's permission was not obtained. It was only because crime branch officers induced that particular clerk to file this register or this offense. Sir, this is out of imagination and anybody can commit any offense through VC. So these are the offenses. So in a way, sir, there are 13 offenses shown against me in FIR. However, only one offense, that is Raupura police station, registered at Raupura police station, appears to have been registered after the promulgation of present act. So, sir, the prosecution was successful in misleading the Honorable Gujarat High Court while adjudicating my bail application. That in spite of his incarceration in jail, he is continuing his unlawful activity, and series of offences are registered against him. Sir, if this Honorable Court peruses my peruses the order passed by Honorable Gujarat High Court on 14th December, which is at serial number 3.
जी.
In paragraph number 6 onwards, we can easily it can be seen that prosecution was successful enough.
So number 3.
6 onwards.
Ji.
Serial number 3. Orange serial number 3.
वाचो ना. Para 6.
Yes. Para 5 I would like to read. It is found out from records that at the time of invoking provisions of pussy talk against the applicant accused, the investigating officer has put much emphasis upon 13 offences registered against the applicant accused. It appears that present applicant accused along with the other co-accused persons as named in FIR formed organized crime syndicate with Chu gang to commit serious crimes relating to bodily injuries and property related and made monetary benefits yielded out from such crimes for their livelihood. Committing such crimes in public, frequently they create an atmosphere of fear and terror. Sir, I will coming to para 6. This is a reproduction of FIR. Considering the FIR of the offence, names and address of all the members of gang and details in the offence are sir, in middle, 13 offences have been registered against the present applicant accused, out of which 3 offences have been filed after the promulgation of the Act.
ना आपको वाचो ना तुम्हें. All gangs and details of offences registered to against each accused in the last 10 years have been mentioned in the impudent FIR.
Name of the present applicant accused is mentioned as accused number 1. Considering the FIR, many offences under section 307, 201, 386, 395, 120B, 143, 147, 148, 149, 387, 506, etc. of IPC section 135 of Gujarat Police and section 25(1)(a) of the Arms Act have been registered against him. In the same way, in addition to the sections mentioned above, offences under different provisions of IPC have been registered against other members of gang. 13 offences have been registered against the present applicant accused, out of which 3 offences have been filed after the promulgation of the Act. So I just demonstrated how those 3 offences are.
No, but against this you have already gone to the Supreme Court.
No, sir.
So,
So after that,
there
were 13 offences registered against. After that, who accused approached Honorable Gujarat. There were 15 offences registered against him. Honorable Gujarat High Court has considered his petition and granted it. Sir, as far as Supreme Court order is concerned, I would like to point out a few things. While my application, when my application before my SLP was heard by Honorable Supreme Court, that was court was not inclined to interfere with the High Court's order only on one ground. That is, that accused was already on temporary bail for 18 days.
okay.
Somebody pointed out that he is already on bail. So Supreme Court immediately refused to entertain my SLP. Any relief under for bail. So that was the main contention. And therefore, if this honorable court sees that order also.
No, ethics है. पहले आप पूरा करिए अपने पच्चीस चले जाइए. 13 offences, only 3 have been filed after promulgation of the Act.
Right.
Now this finding remains there on record.
Right, sir.
Of Honorable High Court.
Yeah, yes.
So how do I sit over this? I say that Honorable High Court was misled.
No, sir. I would point. Sir, after this observation, I went to Honorable Gujarat High Court, and Gujarat High Court was pleased to quash one of these cases.
One of these cases. So बाकी ना तो ये पहला तो रहे ना.
But at that time, that charge sheet was not with the accused. That charge sheet was never produced before the Gujarat High Court. That Anthony's case. Moreover, the other charge sheet was also not produced.
Anthony's case you have adduced.
Now we procured that copy.
But you have adduced it on record of this court.
This court.
Now. Have you done? Okay. Okay. Yes. Read it ahead. Read it further.
Yes, sir. In fact, there are in all total 5 offences have been registered against the applicant accused after the promulgation of the Act, out of which the investigating officer has relied upon 3 offences. Sir, other offences also there, but they are of fine and all. He jumped signal, he did something wrong with police machinery, with traffic police. So therefore, IO has not considered while invoking provisions of this Act. It is worth noting that the other 2 offences have been committed by the applicant accused while he was in jail. It has also come on record from the papers of the investigation that at one point of time, while the applicant accused had attended the court proceedings through video conference, he had administered threat to the employee of the court, due to which a complaint came to be registered against him. Similarly, the co-accused also administered threat to one of the witnesses while on temporary bail and demanded rupees 70,000 to meet with the expenditures of the court proceedings. This has been quashed. The aforesaid conduct of the applicant accused.
Where is that order?
That is at sir serial number 7, orange 7, serial number 7.
Ji.
Yes.
The aforesaid conduct of so
The
and so.
aforesaid conduct of the applicant accused and the other co-accused itself shows the criminal mindset of the applicant accused and his gang members. He is the leader of the organized crime syndicate and seems to be the headstrong person. In all, total more than 200 cases have been registered against the said syndicate, out of which 64 offences are against the applicant accused, and out of those 64 offences, 13 offences have been relied upon by the investigating agency. Sir, these 64, most of the cases have resulted into an acquittal. So, if this honorable court allows me, I did not want to tax the record of the court, but I've got certified copies of all those cases. Sorry. Sorry. All those cases, and he has been acquitted.
Ji.
7. Thus, there is a prima facie material on record to believe that the applicant accused is a leader of this organized crime syndicate and is connected with the other accomplices. Statement of police witness.
Further development has not been on briefed before Honorable High Court, because once the Honorable High Court says
it is not.
કે આ બધું છે, how do I as a trial court, it becomes very difficult for us to this thing.
Right, sir, but there was this ground was also not raised before Honorable Gujarat High Court. Therefore, in SLP, we were not allowed to raise this ground.
Which one?
This ground that and washing is after SLP, but parity co-accused, similarly placed co-accused have been released on bail. That ground.
No, but similarly, he's hardly anybody similar, because he's the gang leader. Supposed
Sir, could you please see that order?
Which one? Parity वाला बधाने gang leader गणिया छे. क्या बताओ?
Para 4, sir. Serial number 5. Serial number 5, para 4.
No, discussion I have heard કરીને એમાં બતાડો ને gang leader ક્યાં કહે છે? Honorable Supervisor High Court.
Yes, sir. Para 6. Para 6. I have heard the learned advocates appearing on behalf of respective parties.
Gang leader કઈ કહેતા જ નથી આને.
Yes.
ક્યાંય નથી.
Sir, in middle. 21-1-21. It is found out from records at the time of registration of offence, total 15 offences have been considered by the authority, out of which 3 offences have been registered after the promulgation of Gujarat Act. Further, as stated above, the co-accused whose names are there in the FIR have been considered.
Gang leader क्या क्या છે આને ભાઈ?
In para 5, 4, para 4.
ये तो submission છે. Court is not here. The court is considering you to be the gang leader. Look at first line on that. First line on the next page of para. On page 7, if you see, very first line, he is the leader of the organized crime syndicate and seems to be the headstrong person. That is the observation of the court. આમાં court કઈ કહેતી નથી કે ભાઈ તમે gang leader છો. So you are on a different footing. You are the linchpin.
That is what they are saying, but sir, ultimately,
Honorable High Court has observed it. How can I?
No, sir. High Court I told that prosecution was successful in misleading.
No, by that I cannot sit over that judgment and say that the High Court has observed by under mistaken fact or something of that sort.
I approach this honorable court.
You withdraw it from here. You go to the High Court and submit
But
this.
sir, unless there is, I raise these grounds regarding parity and defective sanction in trial court, I cannot approach them. That's why I have pleaded specific.
What is the ground on defective sanction?
Defective sanction, sir, on the
Parity માં તો તમને gang leader ગણ્યા છે.
on the date of.
You want to, how do you dislodge this court from this conclusion? Because the court is considering you to be the gang
Sir,
leader.
admittedly, in FIR, I am shown as gang. I think prosecution was again trying to mislead Honorable High Court by showing Atik as a gang leader at the time of argument.
આથી ક્યાં છે આમાં? એવું આવ્યું નથી આમાં.
However, High Court did not buy it.
But that's good enough.
Yes, High Court.
That's good enough.
But again, they were doing same thing. When Atik approached High Court, they were trying to show that he is the gang.
ત્યારે તમે કહેજો કે with this you show this can there it could be that syndicate of members like a panel of leaders might be there. Even we don't know what is your structure.
Right, sir. But in FIR, admittedly, I am shown as gang leader.
Gee, then
I
you
will-
leave it, sir.
I will not.
You cannot run away from it.
Yes. I
Gee.
cannot.
પછી બાકીનું defective charge sheet.
Sir,
Sorry, defective
sanction.
sanction.
So,
Yes.
sir, in order to take cognizance, in order to register an offence under Gujarat Act, Terrorism Act, two sanctions are necessary. One is for registration, that is section 20A,
28. Capital A.
small,
20 subclause A.
right?
હા. વાંચો લાવો તો
Which
મને
describes this, right?
ગુચ્છી ટોકા આપો. લઈ લો. Read it, sir.
Yes, sir. Sorry, sir, my mistake, 22, sir, 22. Notwithstanding anything, my mistake, sir, 22.
Ji.
Notwithstanding anything contained in the code, small a, no information about the commission of an offence of organized crime under this act shall be recorded by a police officer without the prior approval of the police officer not below the rank of officer in charge of range of concerned districts or the commissioner of police as the case may be. This is for registration of offence.
તો કમિશનર ઓફ પોલીસ નથી આવા સેન્કશન.
There is sanction.
Ah.
That sanction finds place in the charge sheet at page number 3, sir.
એક મિનિટ.
Favor, sir.
એક મિનિટ. જી.
Yes. So for registration of an offence,
Hmm.
there has to be prior approval of commissioner.
Hmm.
They have obtained police, crime branch police have obtained sanction from commissioner of police.
Hmm.
However, that sanction has been accorded in most casual and mechanical manner. By ignoring prevalent position of law and various,
બેલ એપ્લિકેશન માં આ દલીલ કરશો બધી.
I have pleaded
ક્યાં છે મને બતાવો.
defective sanction.
ચાર્જ શીટ આપો. અહીંયા હશે આની અંદર અમે રજૂ કરીએ છે ને. રજૂ કરી આપી છે તમે ચાર્જ શીટ. કઈ વાંધો નહીં મંગાવી લો ને બલ્કી છે બહુ. હા એમાં
It is at page number 3. He has considered only FIR. I have seen FIR. I have considered it, and considering the
what else remains lacking, sir?
no, sir, there has to be application of mind whether there is any offence committed by this accused or by this gang which can be treated as organized crime.
Hmm.
Any offence, if suppose any person
એ તો
assaults
શેડ્યુલ માં આપેલા છે ને. એ તો આપેલા છે ને સ્પેસિફાઈ કરેલા છે કે આટલા ગણવાના. So where is the question? It's
there is
clear.
a definition. There is a definition of organized crime.
Ah.
There is a definition of organized crime.
Ah.
So none of the offences
Ah.
mentioned in
તો શેડ્યુલ માં આપેલા છે ને આ ઓફેન્સીસ તો.
but there is no offense, sir. Only offense of Navpura police station is there.
હા.
That too, there are 3 conditions.
Hmm.
In preceding 10 years, at least 2 charge sheet must have been filed.
Hmm.
First, after promulgation of this act, there must be 2 charge sheets of falling under the category of this act. So that very same condition is not being fulfilled because there is only 1 charge sheet.
Hmm.
That is Navpura. Moreover, in that charge sheet, my role is nowhere described. Only because I am the owner of vehicle in which that absconding accused was traveling. Moreover, they have not added any section under section 109, 107 or any section of 120B is involved.
જી.
Sir,
Sir.
sir, the basic requirement
Hmm.
of fulfillment of twin conditions. Sir, while according sanction, there might be High Court, what was portrayed before High Court. During the custody, while in custody, he has committed 2 offences. Those offences cannot be looked into. That can operate as one of the considerations, but legally, to invoke provisions of this act, those offences cannot be looked into.
Sir.
What can be seen? Sir, is whether there were any offences registered which can be treated or labeled as organized crime sitting, organized crime. While according sanction. So for that purpose, sir, I would like to point out Gujarat Act and MCOC, which is prevalent in Maharashtra, are perimeter for each other. So there is that judgment might have been cited before this honorable court on number of occasions. Shiva Sonavne's judgment. Shiva Sonavne's judgment. So, sir, I would like to give brief fact of that judgment. There were two gangs operated. Serial number 5. Shiva Sonam. Sir, there were 2 gangs. First, I will give brief facts because, sir, there are 2 judgments. One is from Bombay High Court and the other one is from Supreme Court. There were 2 gangs. One was headed by Shiva Sonavne. The other gang was headed by Prafulla Shetty. There were 2 gangs. There was gang rivalry. One gang assaulted the member of other and vice versa. And there were number of offences registered against them prior to promulgation of MCOC, that is prior to 1999. Then this act was promulgated in Maharashtra, MCOC. After promulgation of this act, like case in hand, the offences registered prior to 1999 were considered as one of the conditions, and they were invoked, and sanction was invoked, accorded. MOCA was invoked and sanction was accorded. Later on, that matter went to Honorable High Court. Those matters which were registered prior to 1999, that resulted into conviction of those accused persons, and that resulted into conviction. However, after considering those offences, provisions of MCOC were invoked. So, Honorable Bombay High Court in Prafulla Shende's case has held categorically held there has to be substantive offence. In absence of substantive offence, simpliciter MOCA cannot be invoked. Similar is the case in hand. Here, on 19 January 2021 or nearby, not a single offence which can be treated or labelled as organized crime was committed. So what authority has considered that they have considered only previous charge sheets? Yes. So, sir, I would like to point out first case at serial number 6, Prafulla Shende. Because this case has been referred by Shiva Sonavne. This case has been referred by Honorable Supreme Court Justice Partiwala in his judgment of Gupta, Om Prakash Gupta. Sandeep Gupta. Sir, if you could please see document citation at page number 6, B head note, organized crime. Sanction for prosecution. Information recorded was not relating to any substantive offence. Alleged substantive offences were committed much later. Grant of sanction for prosecution would show non-application of mind of sanctioning authority. And ultimately, they were acquitted from all those MOCA cases. Now comes the rival gangs case. Rival gang was also slapped with MOCA case. So that rival gang went up to Supreme Court. And that is Shiva Sonavne judgment, which is at page number 5. Now, I will not burden this court by reading the entire thing, but I can tell sum and substance. Head note A, MCOCA section 3, 21D, 21E, offense of organized crime under section 3, conviction.
This you are reading number 5?
5.
AIR 15. Supreme Court 2947. 2947.
No, sir, it is SCC now. Okay. Actually, I
હા.
am having SCC.
ના કઈ વાંધો નહીં એટલે ફૂટનોટ હેડનોટ જુદી પડશે
Organized crime under.
તમે રેલેવન્ટ પેરાગ્રાફ વાંચી જાઓ ને એમાંથી ખબર પડી જશે
It is there.
ફ્રોમ યોર માર્કિંગ
From head note also it is sufficient. I will read head note only.
જી
Organized crime under commission of offence prior to enactment of MOCA does not by itself constitute an offence under MOCA. MOCA can be invoked only if accused continues with unlawful activities after its promulgation. MOCA can be invoked only if accused continues with unlawful
Yeah.
activities after
Got it.
promulgation.
Got it.
So, sir, for this purpose, I would like to take this honorable court to Gupta's judgment, which is at Gupta 3, serial number 3, sir. Paragraph number 40, sir. Wherein Honorable Supreme Court has considered Prafulla Shende's judgment. Bombay High Court was considered by Honorable Supreme Court.
જી
In paragraph number 47.
જી
Thus, in para 39, sir, Prafulla Shende's judgment is
કોટેડ
considered, quoted, and in para 40. Thus, the High Court took the view, relying on its various decisions, that if no illegal activities as contemplated by MOCA are shown to have been committed after 99, then the past activities prior to 99 may not be of any help for registering any FIR only on the basis of such past activities. Now, sir, it is important. Further, if two or more illegal activities are committed after 99, then the past activities can be taken into consideration in order to show the continuity. So, sir, this is nothing but the reproduction of section 21C, that is continuing unlawful activity. Definition of continuing unlawful activity. Yes. Yes, sir. Now, sir, if this honorable court could please see the
So you say that two or more illegal activities have not been committed after
Right.
90. You, in your case.
after 1st December 1990. 2019. So I'm 1st December 2019. Only one offense was it. And that too cognizance was, sir, now if this honorable court could see the definition, that definition has been considered in part. Sir, in preceding 10 years, one or more charge sheets should be filed. That those offences should be punishable with 3 years, at least 3 years imprisonment. And the court of competent jurisdiction must have taken cognizance of that offence. In our case, sir, cognizance was taken after this sanction, defective sanction was acted. That is 10 February 2021. So, sir, considering Prafulla Shende, Shiva Sonavane and Gupta in this regard, these grounds make this sanction which is being accorded by the Commissioner of Police mechanical and defective. Sir, if this honorable court sees this second head note of the very same judgment of Gupta's judgment, Sandeep Om Prakash Gupta's judgment, rule of interpretation is given.
Just a moment. Yes.
Justice Pardiwala.
Interpretation
Interpretation of
of statutes.
statutes. Strict interpretation. Substantive law should be construed strictly so as to give effect and protection to the substantive rights unless the statute otherwise intends. Strict construction is one which limits the application of this statute by the words used. The basic rule of strict construction of a penal statute is the person cannot be penalized without a clear letter of the law. Presumption or assumption have no role in the interpretation of penal statute. They are to be construed strictly in accordance with the provisions of law. Nothing can be implied in such case. The court are not so much concerned with what might possibly have been intended. Instead, they are concerned with what has actually been said. So, sir, while invoking sanction, the authority ought to have considered the definition of section 21C, that is continuing unlawful activity. They ought to have considered that the court of competent jurisdiction had not taken any cognizance till the date of sanction was accorded.
Yeah.
And therefore that makes this sanction defective. Once initial sanction becomes defective, the entire prosecution case would fall. Sir, as far as present FIR is concerned, I would like to give brief facts of the FIR. This FIR has been registered by a police officer attached to crime branch. After reading his entire FIR, it is nothing but a summary of all the previous cases registered against these accused persons. There are in all 26 accused persons. And he has given only summary. The takeaway is all these offences, according to the informant in this case, the police officer, according to him, this gang has committed all these offences in order to gain pecuniary benefits, which is the condition precedent for invoking Gujarat Terrorism Act. So, sir, after conclusion of investigation, when the investigating officer submitted his charge sheet for getting sanction under section 22P, that time the sanctioning authority, that is government of Gujarat, it is expected from government of Gujarat or the sanctioning authority to consider the material in view of these definitions. After considering the entire charge sheet, not a single evidence is collected by the investigating officer which would show that these offences were committed for gaining pecuniary benefits. Nothing is seized, not a single bank account is seized, not a single property of any of the accused out of 26 is seized. No element of pecuniary benefit is shown. So, at the initial stage, no doubt, FIR is not encyclopedia of events. In FIR, he might think, and whatever he thought at the time of registration of FIR should be substantiated by the investigation, by the evidence collected during the investigation. So, sir, in entire charge sheet, there is no material to show that any of the gang members had any pecuniary benefit.
Yeah.
So, sir, the second sanction, which is mandatory, that sanction is required to only after that sanction this court can take cognizance of the offence. So that sanction is also there. However, that sanction was accorded on 21/5/21.
Yeah.
In that sanction also sans any merit, or that is also mechanical sanction, and therefore on that count also this case falls. Sir, now as far as these definitions, section 21C and 21E are concerned, I would like to point out one judgment.
Yeah. Serial
There
number?
is, serial number 3, sir, Gupta's judgment. There is a difference between an act and activity. What is made punishable by this act is an activity, not the act.
Where does that distinction do you?
Yes.
Where does it discuss this?
Sir, Sandeep.
48, 49.
Yes.
Act and activity is in 50.
Yes, sir, 50, page para 50. Act and activity.
11.
So, previous charge sheets, there might be previous charge sheets, but those charge sheets are not sufficient to label any offense as organized crime.
Read the paragraph, please.
Yes, sir, 50.
There is a vast difference between act and activity. which is being termed or called as an offence in the statute, and such act or activity taken into consideration is one of the requisites for taking action under the statute for the purpose of organized crime.
Yes.
There has to be continuing unlawful activity. They cannot be continuing unlawful
There
activity.
cannot be continuing unlawful activity unless at least 2 charge sheets are found to have been lodged in relation to the offence punishable with 3 years imprisonment during the period of 10 years. Indisputably, the period of 10 years may relate to the period prior to 1/12/19 or thereafter. In other words, it provides that the activities which were offences under the law in force at the relevant time and in respect of which 2 charge sheets have been filed and the court has taken cognizance thereof during the period of preceding 10 years, then it will be considered as continuing unlawful activity on 1/12/19 or thereafter. It nowhere by itself declares any activity to be an offence under the said Act of 2015 prior to 1/12/19. It also does not convert any activity done prior to 1/12/19 to be an offence under the Act of 2015. It merely considers 2 charge sheets in relation to the Act which were already declared as offences under the law in force to be one of the requisites for the purpose of identifying continuing unlawful activity and or for the purpose of an action under said 2015 Act. So now, sir, for this purpose, sir, there are 2 landmark judgments on this point. One is from Honorable Bombay High Court, Sher Bahadur Akram Khan, serial number 9, sir. Red flags. See, sir, I will not read this judgment. I will say, sir, if there is a dispute between husband and wife, husband might be a hardened criminal, and he assaults his wife, and he commits offence under section 307. So, can authorities consider that offence as organized crime? No. Answer is no. He and one of his gang members, let us assume, he and one of his gang members assault his own wife. Likewise, in Sher Bahadur Akram Khan, situation arose before Honorable Bombay High Court, where there was a dispute on over the water tap. Who will fill water first? Because of that dispute, there was a fight. And for that fight, offence under section 324 was invoked. And authorities, while according sanction, considered that offence as organized crime. Sir, only head note 1 is important.
This is 2007 AIR.
Yes, sir, yes.
Bombay
Reporter 320. Right. Organized crime syndicate, offence or unlawful activity committed by a member thereof is to be for gaining pecuniary benefits or gaining undue economic or other advantage for himself or for any other person, or for promoting insurgency. Quarrel at water taps resulting in violence or assault on some person cannot be offence undertaken for pecuniary gain or undue economic advantage. And they have described in what manner the sanctioning authority had accorded sanction. Then, sir, there is a very famous and landmark judgment of Honorable Supreme Court. That is in regard of Telgi fake stamp scam. Ranjit Sharma.
Serial number?
Serial number 2, sir. Now, sir, before going to this judgment, I would like to draw your Honor's attention to mandatory, sir. This is not an ordinary law. Sir, in Ranjit Sharma's judgment, Honorable Supreme Court has declared this act to be a draconian enactment. Sir, this enactment is the indirect contravention to the Indian Constitution. That has been held. But Article 14, Supreme Court did not they took aid of Article 14 right to equality, because Honorable Supreme Court has held equals to be treated equally and hopelessly unequals to be treated unequally. So these people on whom such kind of acts are being slapped, Moka, Tada,
It
Pota.
remains a statute, sir. Whether it's draconian or otherwise, it is still a statute.
Yes, no.
So therefore,
Why it remains statute? Because that has been declared by Honorable Supreme
So
Court.
I understand Justice
It's not-
Pariwara Sahab, when his lordship says that, this has to be strictly interpreted, we interpret it. So that is all you are emphasizing, right?
Right, right.
By this also you are ultimately you are saying that, letter and spirit, the act has to be
That
gone
act
into. That
has
is
to be followed.
ultimately your submission.
No, sir. I'm on different point.
Hmm.
So there is another provision incorporated in this act,
Hmm.
in section 20.
Hmm.
Unlike ordinary criminal law,
Hmm.
there is twin condition has to be satisfied
Hmm.
while granting or refusing bail.
Hmm.
While when any accused
Hmm.
entitled whether he is entitled for bail or not,
Yes.
has to be that accused has to satisfy this honorable court on twin conditions.
Ji.
Those twin conditions can be found in section 20,
Ji. एक मिनट. Okay, there.
subclause 4,
Ji.
20 subclause 4. Notwithstanding anything contained in the code, no person accused of an offence punishable under this act shall, if in custody, be released on bail or on his own bond, unless a public prosecutor has been given an opportunity to oppose. And B, there are twin conditions in B, 20 subclause 4 B.
Where public opposes the application
Where
is satisfied that there is a reasonable ground for believing the accused is not guilty committing such offence.
Committing such offence and that he is not likely to commit any offence while on bail. So this is the twin condition. Sir, similar looking condition is there in MOCA 21 subclause 4. Similar looking condition is there in UAPA Act in section 45. Similar looking condition is there in NDPS.
Ji.
So these two, I have to satisfy this court on these two counts.
Hmm.
Whether he has committed any offence under this act, and whether this honorable court, if releases me on bail, I would commit such kind of offence if while on bail. These are the twin conditions. So for that purpose, sir, I have relied on Ranjit Sharma judgment, head note H.
Your client is not amenable to any law वगैरह. वो तो कुछ ना ट्रैफिक देखते हैं, ना कोविड देखते हैं, ना जेल में ठीक बैठते हैं, ना कुछ नहीं करते हो. He is how can I come to terms with this second condition?
That is what I have.
Such no commission, you will not likely to come.
So as far as out of those twin conditions, second
64
condition
offenses पहले हैं उनके, whether minor or major, but it keeps on adding.
Sir,
He is not.
recently, sir, recently Honorable Supreme Court,
Hmm.
a very recent judgment passed in July 24,
Hmm.
has stated that every saint has a past and every criminal has a future.
इनका past खत्म ही नहीं हो रहा बात.
Sir, if you see the list of offences, he was on the verge of becoming a saint because no offence of whatsoever nature is registered after 50.
फिर से कहे हुआ थोड़ा हमें अजीब लगा. राइम नहीं हो रहा था वो. ठीक. Tell me.
Yes. Sir, so considering this, sir, there are two twin conditions. So as far as second condition is concerned, in Ranjit Sharma, Honorable Supreme Court has categorically held that there is no mechanism available with the court to foresee the future. Court cannot consider. There is no mechanism कि इसको आज छोड़ेगा तो कल जाके ये offense नहीं करेगा. To consider this second condition, there is no mechanism with the court. And as far as first condition is
Courts
concerned,
can only draw inferences. 64 बार तक नहीं किया है और there is no
that
reason of him stopping.
for that,
वो अपना leadership से resignation दे ही नहीं रहे वो.
no sir, there has to be continuing unlawful activity.
हाँ.
Continuing unlawful activity means at least 2 charge sheets post 1st December 2019. But that condition is not being fulfilled. So court.
No, वो
court
तो
has-
आपने argue कर दिया. What I'm
court has
saying
reason
is,
to believe
how do I come to this thing?
because
Whether
of-
December 99
because
or
of this, that might be because of fear of this enactment. He has stopped his illegal activities. That can be considered. Because sir, post 2019, there are no offences which can be treated or labeled as organized crime.
वो तो जेल में है ना तब से तो. 23rd से आ गया.
He is arrested on 1st February 2021.
Okay.
After
So 2 years were there, you said. 2 years, for 2 years he could have committed some offences, but he has not. That's what you
not
said.
committed. So this court can presume that he will not repeat such kind of offense. Now, sir, as far as first condition is concerned, first condition is this court should satisfy itself that he has not committed any offence under this act. As far as this condition is concerned, paragraph number F of Ranjit Sharma's judgment, it has been categorically held by Honorable Supreme Court that there is a difference, there is a distinction between bail application and discharge application. On plain reading
Which
of
is Ranjit Sharma's judgment?
serial number 2, sir. I am giving important para, sir. Paragraph number 46, 49, 54 to 57. And most particularly head note F, sir. Serial number 2, sir.
Ji. Yes, please.
Bail restrictions on grants for positive finding that accused appellant has not committed offence under the act, not necessary. Court, if satisfied that in all probabilities accused may not be convicted, that accused while on bail could not commit offence under MOCA, can order his release on bail. So, sir, I will not take much time. To cut it short, I can summarize these paragraphs.
Does this hold true for even in 24? So this appears to be a 2005 judgment.
Yes, sir. This holds good because in each and every, even Sandeep Gupta's case, this judgment has been given. Even thereafter, sir, in 2024, there is another judgment of Honorable Supreme Court, in which also Honorable Supreme Court has relied on Ranjit Sharma's judgment. And all these three judgments, Shiva Sonone, Praful Shende, and Ranjit Sharma. These are some landmark judgments of this organized crime. So, sir, to cut it short, after considering these paragraphs, head note F, paragraph 46, 49, and 54 to 57, sir, this honorable court has to satisfy itself. Sir, there is difference, distinction is drawn. There has to be distinction. Matter of,
If we come to a conclusion that in all probability he may not be convicted, then that is good enough to hold that he
He's
is not
entitled
committed. He is not guilty of committing.
is entitled from. So, for that purpose, after considering the charge sheet, there is distinction. They have made distinction between bail, consideration for bail and discharge. If on plain reading of these two twin conditions, it may appear to somebody that there should be no material of whatsoever nature in the charge sheet. That is equated to discharge.
Yes.
No material to proceed, groundless charge. So that is not expected while deciding application under 21(4) in MOCA and 20 subclause 4 in Gujarat terrorism.
MOCA is 21, is it?
Yes,
21.
21 subclause 4.
G.
So, sir, there is a distinction between considerations for discharge and considerations for bail. Every accused need not have that better case, which would discharge him. So, prima facie court has to satisfy. Those conditions can be relaxed. So, that is what Honorable Supreme Court has given. Sir, now coming to my last contention. First, sir, there cannot be simplicity of terrorism. There has to be some or the other substantive offense committed. In present case, there is no substantive offense. So, sir, after considering no simplicity of MOCA, therefore defective sanction, there has to be strict construction act or activity. So, after post 1st December 2019, there have to be 2 charge sheets. Then, sir, last contention, that long incarceration. Sir, there are 3 judgments of Honorable Supreme Court. First one is K.A. Najib's judgment. Serial number 11.
G.
First judgment is of K.A. Najib, NI versus Najib. In that judgment, sir, Honorable Supreme Court has categorically asked all the courts inferior or the Supreme Court also to relax the twin condition, mandatory twin conditions envisaged under UAPA.
Where does it say?
Yes.
Paragraph.
Sir, paragraph C. Head note C. Head note C.
This is a different
UAPA.
citation.
UAPA.
AIR है, आप SCC पढ़ रहे हैं. जनरली वो ऐसा समझते हैं कि हेड नोट में क्या पढ़ना, तो कोई भी साइटेशन हो सकता है ना. एंड इज राइट टू दैट एक्सटेंट सर. साइटेशन ये तो कोई और प्रिपेयर करता है. आप पैराग्राफ नंबर से पढ़ दीजिए.
Sir, in UAPA section 43.
Just to read the paragraph, concerned paragraph, they'll mention in SCC the paragraph numbers in the head note itself. Those paragraphs you can just simply read.
Yes. Union of India versus K.A. Najib.
This is the judgment in the yes versus K Najib. I have that judgment. Paragraph number you tell me. आपका SCC citation है ना वकील साहब?
हाँ.
तो उसमें नंबर तो देते हैं, पैराग्राफ नंबर एट द एंड ऑफ ईच ऑफ द हेड नोट. अब वही पढ़ दीजिए.
Para 19.
हाँ तो पढ़िए 19 adverting to the take out that paragraph and read it.
I found out. Yeah, sir.
हाँ.
FIR registered against accused of offence under section 3 of explosive substance and section 16, 19, 20.
वो उसमें नहीं है. First this thing does not say about relaxing. Possibly text of that paragraph 19 will tell you.
Right.
It does not say that you know kind of read down this condition. That is what your submission is, right?
Yes, sir. Yes, sir.
तो पढ़िए उसको जरा.
Sir, I will summarize.
नहीं पर ये मैं पूरा थोड़ी पढ़ूंगा. आपको you have to read it.
I'll point out what has been held in AK Najib Union of India.
जी.
That has, as far as twin conditions are concerned, similar looking twin conditions are there in UAPA also.
Correct.
UAPA, Mocha and Gujarat terrorism.
Correct.
Same conditions, twin
Correct.
conditions.
Correct.
Those twin conditions can be relaxed if there is long incarceration of the accused. So,
How much was the incarceration in this?
5 years, almost 5 years. Now, in case in hand, there is almost 4 years. Almost 4 years. Sir, I will read that head note and then give you paragraph number. Para C, grant of bail, statutory restrictions under section 43T subclause 5 of UAPA when not material. Long period of incarceration and unlikelihood of trial being completed.
आपको हेड नोट पढ़ रहे हैं आप 19 पढ़िए ना. हेड नोट तो है नहीं वो मेरे पास, तो कहां से मैं पढ़ूंगा?
Yes, sir. Adverting to the case in hand, we are conscious of the fact that charges leveled against the respondents are grave and serious threat to society, social harmony. Had it been a case of at the threshold, we would have outrightly turned down the respondents.
18 पढ़ना पड़ेगा आपको.
Yes. It is thus clear to us that presence of statutory restrictions like 43D subclause 5 of UAPA per se does not oust the ability of constitutional courts to grant bail on ground of violation of part 3 of Constitution. Indeed, both the restrictions under the statute as well as powers exercisable under constitutional jurisdiction can be well harmonized. Whereas at commencement of proceedings, courts are expected to appreciate the legislative policy against the grant of bail, but the rigors of such provisions will melt down where there is no likelihood of trial being completed within a reasonable time and the period of incarceration already undergone has exceeded a substantial part of the prescribed sentence. Such
What is
an
the
approach,
punishment prescribed to this act?
sir, as far as section 3(1) is concerned, there is, if death of any person is happened, then there is life and death also.
लाइफ का तो हाँ,
हाँ,
तो लाइफ सब्सटेंशियल पोर्शन कैसे हुआ ये?
I will point out.
Hmm.
So ultimately, in AK Najib, those conditions can, court has held that those conditions can be melted down. Then, sir, another judgment came from Honorable Supreme Court in this year, in the month of February, wherein two judges, this judges is of three judges, this judgment is of three judges bench. Then two judges judgment came in respect
आप
of you.
पहले आंसर करिए इसको. How is this a substantial portion undergone?
Sir, as far as section 3(1) is concerned, that cannot be invoked against me. Police have leveled it, but that cannot be invoked because, sir, I would like to read that section 3. Again, it goes to the root of the case.
जी.
Because no simplicity offense can be registered. Sir, if
3(1) में कितना? See, you are
3(1) में life.
3(1) में life है ना?
हाँ, death or life. But sir, for invoking 3, there has to be death. Whoever commits an offense of terrorist act or organized crime.
There is no allegation of 302 against you.
No.
No allegation.
No. No offense is considered under 302.
उसमें क्या बोला है?
हाँ. Whoever commits an offense of terrorist act or organized crime shall, if such offense has resulted in the death of any person. So, sir, post 19, there is only one case, that is 212.
No death has resulted.
No death has resulted.
Even from previous continuing
No,
activity.
No, not previously also. So 3(1) would not be applicable against you.
जी.
And 3(2) is up to 5 years. Now I am behind the bars for almost 4 years. In January, I will be completing 4 years.
Okay.
If scheme of this act is seen, sir, if this honorable court sees section 11, we read section 3, and section 11 is also important, sir. If section 11 is seen, if this honorable court finds that there is no substance in proceeding with the trial under Terrorism Act, then this court can transfer that matter to lower court. If similar situation arises here, if this court finds that there is no material to proceed against these accused persons under Gujarat Terrorism Act, then where this matter will go? This matter will be closed forever, sir. This cannot go anywhere. So this scheme of this act shows that there has to be some or the other substantive offense. There cannot be simplicity offense under Gujarat Terrorism Act, like this case. Sir, A.K. Najib's position was disturbed by some other judgment in 2024. Again, Supreme Court Justice Pardiwala restored it. Justice Pardiwala has held that A.K. Najib's judgment still holds good water because it is of 3 judges bench. 2 judges bench judgment cannot disturb that position, and we concur with the earlier judgment, that is A.K. Najib's judgment, and that judgment has been cited by me, which is at serial number 12. Sheikh Javed Iqbal.
Justice Pardiwala sub judgment.
Yes. Usual Goyan and Justice Pardiwala. So they concurred with A.K. Najib's view. Yes. So, sir, so this long incarceration is also there. Sir, facts can be seen. In this case, sir, charge has been framed in the month of February. However, till today, prosecution did not find time to produce any witness before this honorable court. Sir, there are in all 224.
Charge framed on
February 2024. Sir, there are 224 witnesses cited in the charge sheet. Even if trial is commenced, nobody can guarantee when it can be concluded. It is 21 to 2024 framing of charge. Sir, if all these witnesses versions in their statements is taken and its face value, who are these witnesses, sir? 99% witnesses cited in the charge sheet are police witnesses. They are none other than the police officers from investigation team who conducted investigation in previous charge sheets, previous cases. Therefore, sir, one cannot lose sight of Article 20 subclause 1, Article 20 subclause 2, and Section 300 of CRPC, and doctrine of double jeopardy. These three provisions, Article 20 subclause 2 and Section 300 of CRPC, are nothing but doctrine of double jeopardy. So
Why doctrine of double jeopardy?
double jeopardy because, sir, in earlier cases, these accused persons have been acquitted. Again, this investigating officer has recorded statements of the then investigating officers.
That is a difference offense. This is a difference offense.
No.
Double jeopardy can be.
No, sir. Those
Act section does not say that, for the same facts you cannot have two. It says for the same offense you cannot try for two. So if it's a difference offense, this is an independent offense in the
this is independent offense. But what suppose in an earlier case which is registered, those 13 cases are shown against him. If one of the investigating officers comes, the witness box, what he is going to depose as per his statement. Such and such offense was registered. I had investigated that
Act provides this would have been gone to constitutionality challenge
in 3 cases, constitutional validity was challenged. However, it has been upheld. It has been upheld. So, sir, this investigating officer, he has failed to appreciate current position of law while invoking MOCA, Gujarat Terrorism Act, and while
otherwise applicability, maintainability of that proceedings any વાત કરી છે.
So at that time, he did
transfer
not
ને બધું
know.
double jeopardy વડે કઈ ખબર ના પડી તમે કઈ રીતના.
Sir, one minute. I'll point out. At that time, he did not know that such evidence should not be collected. At that time, he was not knowing the investigator. Therefore, he collected evidence which is barred by law. Section 300 is there.
How is that barred by law? મને ખબર ના પડી. See, what you seem to be saying is that there was an offense. At that point of time, they were tried, whether it's respective of the outcome, whether he was acquitted, not acquitted, or is still pending. It is evidence has been laid in those courts. Now you say that that very evidence is going to be here because in this proceedings, the precondition of invocation of these proceedings is that there should be certain offenses within a period specific time limit 10 years, and thereafter invocation of this after the act coming into force there has to be certain offenses. How do I prove those offenses? Because those offenses cumulatively are culminating into a fresh offense. Now if it is a fresh offense, then this double jeopardy does not apply. તમે કઈ જુદું જ કરીને કોર્ટને વાતો કરો છો.
For that purpose, there is a judgment of Honorable Supreme Court as well as Honorable Bombay High Court, in which says if in MOCA trial, earlier investigating officers should not be examined because court is not concerned with the facts or outcome of that case. Court is concerned whether that offense was
So
punishable.
then the trial would faster. It is very good then.
Yes.
These offenses,
I cited that judgment. Prafulla Shende only. In Prafulla Shende.
paragraph बताओ.
In Prafulla Shende.
एक मिनट बताओ मैंने.
What needs to be proved, sir?
प्रफुल्ल शिंदे होता है कि शेंडे होता है वो?
Shende. SHEND. Shende.
शेंडे.
Which is at serial number 6, sir. What has to be?
एक मिनट. Serial number 6. Yes, please. Paragraph.
Paragraph 9. Paragraph, sir, 42 onwards. It means 41 onwards, but relevant is 43, 40.
Yes.
In page number 17.
Yes, yes, मिल गया 42.
Yes, sir.
The
This
court then
45
rejected.
conclusion is mere proof
नहीं
of
नहीं नहीं
finding
आप
that
आप कौन सा पढ़ रहे हैं? Serial number
Prafulla Shende, sir.
serial number 7.
7.
एक हमारी कोई
No, sir, 6, sir, 6. 7 is subjection.
हाँ तो उससे बराबर है ना 6
6.
6 में पैराग्राफ 42 की आपका एससीसी पढ़ रहे होंगे आप
No, sir. Yeah,
एआई में 42 the court then rejected
हाँ.
the objection.
right.
ठीक है ना? हाँ
हाँ.
पढ़िए.
Next, 43. This fortifies the conclusion that mere proof of filing charge sheet simply passed is not enough. It is only one of the requisites for continuing constituting offense of organized crime. If only past charge sheets were to be enough to constitute the offense of the organized crime, it could have offended the requirement of
ये
article.
दोनों हर जगह ऑफ को अलग कर देता है वो ऑफेंस को ऑफेंस कर रहा है वो और ऑफेंड को ऑफेंड किया हर जगह ये किया यस
Of Article 20 subclause 1 of Constitution and possibly Article 20 subclause 2 as well, and in any case Section 300 of CRPC. Had these judgments of Supreme Court and division benches of this court been cited before the learned single judge dealing with Amarnath versus so and so, the learned single judge without doubt would not have held that manner was. Next paragraph, sir. It is not necessary to go into implications of the expression prosecuted and punished used in Article 20 subclause 2 of the Constitution. Section 300 CRPC itself clearly bars a fresh trial for the same offence. Section 21 of MOCA, which prescribes modified application of the code to offence under MOCA, does not make provisions of Section 300 CRPC inapplicable. Therefore, since the previous criminal history of the applicants denotes that they had been or being separately charged or tried for those offences before competent courts, there is no question of such offence constituting offence of organized crime. And henceforth it has been held, sir, only by one line. This investigating officer has to obtain certified copy. That certified copy has to be placed on record. Court only needs to see whether offence is punishable with 3 years imprisonment. One, whether on the date of invocation of provisions of MOCA or Gujarat Terrorism Act, the court of competent jurisdiction has taken cognizance of that offence. Only these two facts are to be proved. So if that they come with.
Sir, then what you say is that trial is not likely to conclude is not true because all of these of 99% of the witnesses would be dropped. That is what you are suggesting.
Yes, I am suggesting that. But they have
So,
cited they have recorded statements.
nothing compels them to cite.
How many witness? But they have not given any witness list also. So as on today, we have to take that number that goes to 224.
Has this been agitated before that? You know the things that you explain.
In some
So
other court, there was similar provision. So the same was argued that Article 300, Section 300, Article 20 subclause 2 is being jeopardized. However, that court passed some different order.
नहीं उनका तो यही कहना है कि it is not as if it is evidence is laid. They have only to show that these two things are to be done. So 300 would not be applicable in your double jeopardy will not apply. That's what I am trying to tell you.
That is what it has been held. And double that this act does not take.
Sir, when that evidence itself is not admissible, because you have to just see that there is a previous offense and that cognizance was taken. If that is the only thing, you are not tried for that offense per se, then where is the question of double jeopardy?
Now, this honorable came to know. Prosecutor may not know that. Investigator may not know that. So they have cited 224 witnesses. That is what I am pointing. Yes.
There is propulsion there, right?
Yes, sir. Propulsion.
This is a Bombay High Court. Has
Yes,
this
sir.
position been reiterated in so many words in, if this concept of explaining as to what is to be proved and not the entire evidence which has to be proved. Has it been explained in other place where either by Gujarat High Court or by Supreme Court?
Yes.
Not yet.
Yes, not yet. But Prafulla Shende still holds water because yes.
Yes.
Sir, so sir, this is the situation. So he is almost gang the last for 4 long years. So sir, now my next submission is everywhere it has been stated that he is a gang leader. He is a gang leader in FIR, in earlier orders, in everywhere, in their affidavit. Now, sir, I would like to state before this honorable court. The term gang leader is not recognized by law. Sir, as
Should
far
we
as
provide for registration of gang leaders? कि भाई law
Yes.
recognize कर दे.
sort of, because there are big gangs like Dawood Ibrahim gang, Chota Rajan gang. So everyone knows that all the associates or aides are working under them. So it is not case in hand. It is not like that. So sir, term gang leader is nowhere described. Only organized crime syndicate is described. And being a member of organized crime syndicate is made punishable. So sir, if at all any person is to be labeled as a gang leader, there is no different yardsticks. What is punishable? Being a member of gang is punishable under 3(4), section 3 subclause 4.
So you say that all are at parity.
There are no different parameters or considerations for different names. Now, sir, last submission, my citation, which is cited at serial number 1, sir, Babu Singh. On many occasions, it might have been cited before this honorable court, but I would not stop myself from reading only 3 lines from that. Serial number 1,
Yes.
J.L.Odedra 1. Babu Singh versus
Criminal law journal से.
Criminal law, yes, 651. Sir, this is most celebrated judgment of Justice Krishna Iyer. Sir, criminal bail. Appeal before Supreme Court, application for bail rejected at earlier stage. Order refusing bail does not bar fresh application on later occasion, giving more details, further developments, and different considerations.
Okay.
So, sir, whatever I argued before this honorable court, these grounds were never ever raised before Honorable Special Court or Honorable Gujarat High Court. So, sir, giving more details, further developments, those 3 out of 3 cases, one has been quashed. Other case cannot be considered as organized crime, and the only remaining one case, which is from Nawapura police station. Raupura police station, that I have argued, Anthony's case. So, sir.
Thank you.
Please. Sir, stringent conditions can be imposed, even if he is released. Stringent conditions can be imposed. His daily attendance can be prescribed. Heavy sureties can be prescribed. He cannot. Restrictions to enter this city can be imposed. Sir, howsoever stringent conditions this honorable court imposes, I am ready and I am duty bound to follow, abide by this. My humble submission, sir, considering his long incarceration, considering the defect in both the sanction orders, he may kindly be removed from this. Yes. Sir, unfortunately, I forgot to place this order being on record. When I went to Supreme Court, in Supreme Court, my SLP was dismissed on withdrawn. It was not dismissed. I was allowed to withdraw. It was withdrawn on 24 May 24. 24/5/24. And at that time, I was on temporary bail, granted by this honorable court, the predecessor court of this honorable court.
Which is that order? Temporary bail one?
Temporary bail application number 551 of 24.
જી.
Then I'll place that order.
બીજું આમ લઈ લેજો ને.
To place.
એ લિસ્ટમાં એડ કરવા દેજો. હા, હા. બીજું કઈ છે વકીલ સાહેબ?
हाँ जी सर इसमें ऐड कर दीजिए ना
हाँ.
Yes.
Serial માં 38 નંબર.
જી.
સર ટાઈમ આપેલો અમને આજે તો માટે પણ મારા ક્લાયન્ટ છે ને હોસ્પિટલમાં એટલું જ ગઈકાલે રજા આપો છે.
More than ample opportunity is given to them for settlement. In fact, last so many occasions,
તો
they
પેલી
did
મંગાવી
call-
રાખો ને,
they did acceptable court.
RNP મંગાવી રાખો આની અંદર. આવી ગયું છે? જી સર. મંગાવી લેજો ને. નથી? ઓકે. ના થયું તો ના થયું. If you are
ના,
not
પણ
settling.
anyway, પણ એના માટે સાહેબ એ લોકો જે 40% amount જે deposit કરવાની છે decretal amount આજ દિન સુધી કરી નથી.
તો એ dismiss કરી નાખો.
Only on reason of settlement only honest.
હા?
તમને કોઈ ડિસ્કસ કરી દઈએ બેટા.
શું?
એથી ઓર્ડર કરી દો અને
શું ડિસ્કોઝ કર્યું?
એ ઓર્ડર જે પાડે તો ઇન્ટ્રી ઓર્ડર
Stay of orders of judgment and decree which is still in force.
નથી.
Subject to depositing 40% amount of decretal amount.
એ લાવ એ આજે તમે ભર્યો છો કેટલો સમય આપ્યો છે
નથી
તમને?
ભર્યો સાહેબ, ભર્યો જ નથી અમે.
તમે કેટલા સમયમાં તમને આપ્યું તો ટાઈમ કોર્ટે?
અને સાહેબ sufficient time આવ્યો હતો સાહેબ.
પેલી કરતા હું અત્યારે જતો રહ્યો.
તો એ નહીં હવે ઓર્ડર તો ખબર પડી જશે ને તારીખ?
Order તો
કાઢો ને.
પણ અને એવું
હા.
નથી સાહેબ,
તમે ના ભર્યા હોય તો then it cannot
અને હજુ સુધી નથી ભર્યા, સાહેબ.
continue in your favor. If you don't settle the matter.
એમાં એવું છે એમની દરખાસ્ત સ્ટે કરવાનું હતું ઓર્ડર હતો અને એ દરખાસ્ત સ્ટે થઈ
ના as such no stay.
હા?
એ દરખાસ્ત ચાલુ છે
સાહેબ કોઈ
ચાલુ છે.
stay આપવામાં નથી આવ્યો
આ
સાહેબ.
નથી આપ્યો ને નથી આપ્યો હું ક્યાં પૂછું
અને
દરખાસ્ત ચાલુ છે.
દરખાસ્તમાં સાહેબ એવી
તો
રજૂઆત
તો પછી દરખાસ્ત
દરખાસ્ત ચાલુ છે,
they have
સાહેબ.
press for it sir.
હા.
ના ના સાહેબ દરખાસ્તમાં શું રજૂઆત થાય છે કે નીચે ફર્સ્ટ એપેલેટ કોર્ટમાં સ્ટે આપ્યો છે 40 સબ્જેક્ટ ટુ ડિપોઝિશન ઓફ
ક્યાં એવું ક્યાં stay થયો? એ તો તમારે કહેવાનું છે ને ત્યાં. How can the-
ના એટલે સાહેબ દર વખતે આ લોકો એ ઓર્ડર દરખાસ્તમાં એ જ મૂકતા હોય છે કે ફર્સ્ટ એપેલેટ કોર્ટે સ્ટે આપ્યો છે એટલે અમે દરખાસ્તના કામે આગળ કોઈ
ક્યાં
કાર્યવાહી
કયા ડોક્યુમેન્ટ થી મૂકે છે એ લોકો?
એ સાહેબ ઓર્ડર સર્ટિફાઈડ કોપી મૂકી છે સાહેબ ઓર્ડર
કઈ સર્ટિફાઈડ કોપી બતાડો ને એમાં ક્યાં સ્ટે નું છે કઈ?
સ્ટેનું નથી સાહેબ પણ જે 40% અમાઉન્ટ ડિપોઝિટ કરવાની હતી સબ્જેક્ટ ટુ ડિપોઝિશન ઓફ સર્ટન અમાઉન્ટ
ક્યાં છે order? દેખાડો મને. એ ઓર્ડર દેખાડો મને.
એ સાહેબ રેકોર્ડ પર જ છે
રેકોર્ડ
order.
છે, સાહેબ.
લાવો ને મને દેખાડો.
એ દરખાસ્ત-
તમે you don't even bring the file or ત્યાંથી મારી ફાઇલમાં
સાહેબ,
મારે
actually એવું છે કે એમના વાત ચાલે સમાધાન દસ્તાવેજની તૈયારી બી છે એક બે દિવસમાં
ના ના સાહેબ કશું નથી થવાનું એમ.
નહીં થાય કામ હું તો સાહેબ આર્ગ્યુ બી કરીશ next time. હું એવું કદી નથી કહેતો પણ જે
I will clarify that there is no stay.
એ હાલ નથી તો દિશે
એ હું clarify કરી દઉં છું આજે.
દરખાસ્તના તમે ચાલુ છે પેન્ડિંગ બી છે સાહેબ દરખાસ્ત.
કયો 40% ભરવાની વાત છે બતાડો.
મેં સાહેબ સ્ટે કરવા માટે અરજી આપી હતી દરખાસ્ત પણ સાહેબ 40% રકમ ભરીને સ્ટે કરવાનું કામ કરેલું મેં પૈસા નથી ભર્યા એટલે દરખાસ્ત ચાલુ છે હજી.
ના ભાઈ એટલે હું આજે કહી દઉં કે આજે now the time to pay 40% amount is over એવું કરીને હું ના પાડી દઉં છું. હવે there is no express stay recall કરી લઉં છું. That liberty
સાહેબ, તે order કરેલું છે લગભગ maybe સાહેબ order
that
કરેલું.
liberty also I will revoke. Because if you don't pay 40% then where is the question?
તમે એના કરતા 50 લાખ રૂપિયા already આપી ચૂક્યો છું સમાધાન પેટે એવું પણ નથી કે નથી આપ્યા પેમેન્ટ
એટલે એ પછી order થયો છે ને?
હા એને પછી એને પહેલા order
એના પહેલાનો
એને
order
પહેલાનો order છે.
એના પહેલાનો
એના
order.
પહેલાનો order છે ને 40% નું કેટલા ભરવાના થાય છે?
8 કરોડ સાહેબ 8 કરોડ
એ તો સાહેબ more than 5 કરોડ થઈ જાય છે ને ડિક્રીટલ અમાઉન્ટ સાહેબ 12 કરોડ એ 8 કરોડ છે સાહેબ.
હા તો 8 કરોડ માંથી 40%
ખાલી-
કેટલા થાય? તમે 50% એટલે તો 10% નથી ભર્યા. 40% શું?
નથી ભર્યા.
આપ્યા છે સમાધાન પેટે મારું બાઇન્ડિંગ ગોડા
એટલે તમે કરજો ને, કોણ ના પાડે છે? You have not withdrawn. લાવો એક એપ્લિકેશન આને સુધારા કરવા માટેની એપ્લિકેશન આપો હું કરી દઉં અત્યારે. This is a application under order dated. હા એમને બતાડો.
સાહેબ એક્ઝિબિટ 2090 છે સાહેબ.
હા આર્યો છે બતાડ્યો મને. This is the order. આ પણ and you move an application that this be recalled. They have not passed. This is almost 4-5 months.
ઓલમોસ્ટ પરફોર્મન્સ
Because April થી તો હું અહીંયા છું. આ અમારા predecessor સાહેબના
એના
ઉપર
પહેલાનો
હતો.
છે.
હે?
July 20.
હા તો હજી સુધી એટલા you file an application and allow that application.
પણ સાહેબ એમાં વચ્ચે આ લોકોએ સેટલમેન્ટ માટે ઘણા એ કર્યા તો વી આર રેડી ટુ સેટલ ધીસ મેટર કોઈ કારણસર ના થયો એટલે
તમારે-
that I am not insisting for certain things.
એ જે સેટલમેન્ટ કરવાની વાત છે ને એ તો તમારે બંનેને જોવાનું છે. કોર્ટને ખબર નથી પડતી એની પાસે પૈસા છે કે નથી, whether he has or not. But appeal ચાલે. But if he is staying your execution proceedings, then I am calling upon you to invite an application કે ભાઈ આ ક્લેરિફાઈ કરી આપો કે અત્યાર સુધી ના ભર્યા હોય તો એ નહીં ભરે ને હું લિબર્ટી પાછી લઈ લઉં. પછી એને ભરવા હોય તો ડાયરેક્ટ તમને આપે. You can stall execution if you yourself decide, not at his instance. He cannot say કે ભાઈ આ ઓર્ડર છે ને હું ભરી આપીશ અને કોર્ટ અચકાતી હોય તો I can pass further order saying that
તો હું
since
સાહેબ એક
23
રીતની હું અરજી આપી દઉં છું એના માટે વેકેશન માટે એક અરજી આપી દઉં છું
હા હા
એ રીતની મેં એક અરજી આપી દઉં છું
હા
સર
કે ભાઈ I is not court declare that there is no liberty now remain because 40% એમણે ભર્યા નથી કશું. If he does not pay, then court cannot, and you cannot wait for endless time. તમને જુલાઈ થી આજ વર્ષ દિવસ થયું.
એક બેટી સમાધાનની વાતચીત ચાલે છે.
ચિંતા કરો એ કરજો ઘરે જઈને સમાધાન તમે બંને જણા.
દસ્તાવેજની તૈયારી બી છે એમને બી ગઈકાલે બી દસ્તાવેજની કોપી આપી
કઈ વાંધો નહીં તમે whenever you move application ત્યારે મને કહેજો.
સાહેબ નેક્સ્ટ વીકમાં રાખો સબ્જેક્ટ ટુ ઓનર્સ કન્વીનિયન્સ અને મીન ટાઈમ સાહેબ જો ઓર્ડર
We are on 12,
આવે
so 19.
19
જી.
ઓબ્લેસ
એમની અરજી છે.
અને હવે મારે શું આશાના માટેની અરજી છે મુદત
આજે પક્ષકારોને હાજર રાખવા સૂચના આપેલી હતી.
તો સાહેબ છેલ્લા 3 ટાઈમથી એ પક્ષકારોને હાજર રાખવાનું કહે છે પણ એ નથી.
ખાલી રેકોર્ડેડ કરું છું આની ઉપર. You recall મને યાદ દેવડાવજો આવો
recall માટે અરજી લઈને જ આવીશ સાહેબ હું આ તારીખે.
લઈને આવો ત્યારે કરી દો ભલા ને રેકોર્ડેડ 19 લાવ એડજર્ન કરી દો રેકોર્ડેડ 19/9
રેકોર્ડ આવી ગયો છે રેકોર્ડ છે રેકોર્ડ મંગાવ્યો ને તમારી અપીલ છે
હાઈકોર્ટમાંથી
હાઈકોર્ટમાં તો છે.
એને
બીજું કયું
ચાલુ
record?
છે.
એ હાઈકોર્ટ ગયું હતું ને હાઈકોર્ટમાં. એ તો આવી ગયું હા
હા અપીલ શેના પરની છે?
કોમર્સની ઓર્ડર
તો એ રેકોર્ડ મંગાવવું પડશે.
એ હાઈકોર્ટમાં છે.
અરે અહીંથી હાઈકોર્ટમાં ગયું જ નથી ગુપ્તાજી શું તમે ખબર નથી ને બોલો છો
હા એ હાઈકોર્ટમાં અપીલ થયેલી દાખલ અહીંયા નથી દાખલ થઈ.
ખાલી અપીલ દાખલ થઈ છે રેકોર્ડ તો સાહેબ અહીંયા જ છે હા કારણ કે એ સાહેબ પેલું પેપર બુક આપવાની હતી પણ મેઇન ટાઈમ શું થયું કે જ્યુરિસડિક્શન એક્સપાન્ડ થયો એટલે અપીલ હાઈકોર્ટ ત્યાં આવી ગઈ સાહેબ
અચ્છા
એટલે રેકોર્ડ તો અહીંયા જ ઓબ્લેસ
શું છે બીજું
દરખાસ્તમાં સાહેબ સોગંદનામું આપી.
હા લાવ
આપી દીધું.
લાવ ત્યાં છે. બસ બરાબર હવે આપી શકો ભાઈ ક્યાં ગયા તમે ચેક આપી શકો
ડ્રાફ્ટ આપી શકો એમને.
બરાબર અને ત્યાં કોર્ટમાં આ લોકો સપોર્ટ કરશે આપના કેસ
મેં એમને એ કહ્યું 17 તારીખે આવશે તમે હાજર રહેજો અને તો સપોર્ટ કરશે.
કઈ તારીખ છે ત્યાં
17 તારીખ હા આ 17
આ આવતીકાલે જ ત્યાં બોર્ડ ઉપર લેવડાવીને પૂરું કરાવી દો ને
તો મને કશો વાંધો નહીં એ જશે એમના વકીલને કહેવાનું છે.
તમે અને તમારા વકીલ કોણ
તમારા વકીલ કોણ
તમારા કોણ છે ત્યાં વકીલ ભાઈ
એ તો છે મેં રોકેલા છે એમને કહી
તો
દઈશ.
ત્યાં કાલે હાજરી દેજો બંને પક્ષકારો બંને જણા હું આપને છે ને આ લોક અદાલતમાં જ આ પેલો ડિમાન્ડ ડ્રાફ્ટ આપીશ કાલે શું થાય મને રિપોર્ટ કરજો લોક અદાલતમાં 14 તારીખે
ડ્રાફ્ટ હજી એમની પાસે છે ડ્રાફ્ટ પાર્ટી
ડ્રાફ્ટ અહીંયા જમા કરાવી દો અથવા તો નાઝીરનો હુકમ કરી દઉં છું ડ્રાફ્ટ બી ડિપોઝિટેડ વિથ નાઝીર એવું કરી દઉં છું
કારણ કે મેં વિડ્રો પુરસીટ લખી છે એટલે
એ બધું થઈ જશે તો મારે જોઈએ છે કે ત્યાં પેલા બીજા
એ વાત ન આવે.
ત્યાં જાય અને 14 તારીખે તમે ભાઈ અહીંયા આવીને ડ્રાફ્ટ લઈ જજો તમે કાલે આવતીકાલે જઈને વકીલ મારફતે લઈને વિડ્રો કરાવી નાખો ત્યાંથી વિડ્રો કે સેટલ આવી ત્યાં બી કરાવી નાખો કે અમારે વી ડોન્ટ વોન્ટ ટુ પ્રોસીડ વિથ ધીસ મેટર હા 14 તારીખમાં રાખો હા
14 તારીખે
ડ્રાફ્ટ કઈ જમા કરવાનું છે
ડ્રાફ્ટ અહીંયા જ એમને આપી દો ને
એમને આપું
સાહેબને હા જ ને
એ નહીં ઓરિજિનલ
હારી ઓરિજિનલ આ રહ્યો છે તો ઝેરોક્સ
નાઝરમાં જમા કરાવી દેજો અહીંથી મિસપ્લેસ ના થાય
જી જી
આપણે નહીં તો પેલો ભાઈ આપણે પકડશે જી શું છે
14 તારીખ જવાનું બરાબર તો કાલે તમારે ત્યાં દેવાનું.
તમારું શું છે આપનું
એક આરોપી છે આજની તારીખમાં કેસ છે સાહેબ
હા.
આપણે એનબીડબ્લ્યુ ઇસ્યુ કર્યું હતું
હા.
અને એને પકડીને લાયા છે એના કોઈ વકીલ છે નહીં
સાવલી તમારે જવાનું
પોલીસ સામે કઈ ફરિયાદ છે ભાઈ?
આગળ પાછળ થઈ.
અચ્છા.
અરે સુનિલ ભાઈ એક મિનિટ આવો ને બોલું ઉપર આવો ને ફટાફટ આજે ને રવિભાઈ ને આપો અમને દિવાળી આરોપી આપી દો
અને આ કરાવી દો તો
હું કરી દઉં.
ઓકે થેન્ક યુ.